with agents group. So the regulations are almost ready, and we expect to refer these regulations to the Council this year, with the idea in mind that the regulations will come into force as from 1st January 2022. And finally, last but not least, as we say, in terms of education, we can present the FIFA Global Integrity Program, just launched days ago, 3-4 days ago. I'm presenting this, something like we are going to do. Indeed, the program is now running. So it's a global initiative from FIFA in cooperation with the MAs and the confederations to extend our knowledge and extend our capabilities in terms of integrity, the fight against match fixing. Again, the program is running. The first module is moving ahead with the Asian Football Confederation, but also a very nice and social, I would say, initiative from our side in 2021. That's all from my side. Again, as I mentioned in the beginning, we have planned a very interesting FLAR for 2021. So we have now good presentations and nice presentations from player status department, cash cases, disciplinary and ethics, and then our very good friend Sam Cottrell will introduce sports law matters in 2020 outside football. That, you know, as the president mentioned, it's not only football, but it's football. But you know, sports law is more than football law, and that's why we invited Sam to give this presentation later in the afternoon or in the evening, and then tomorrow the team will be focused on the new decisions and regulations passed in 2020, starting with the amendments to the statutes and the rules for representing national teams. Again, I wish you a very nice FLAR. Today's talking about football law and sports law. It's really nice for those who love this. Definitely, I love this. I'm very passionate about all these matters. So I will be here with all of you, with Maya, with the legal team. And that's all from my side. Thank you very much, Maya, and enjoy the day. Thank you.
Thank you, Emilio. We are aware that it's not working properly. So I have been receiving several messages, and I also have notes it in here. So I know that the YouTube stream is not working properly. We do apologize for this. We know that whoever received the link of Zoom is able to follow us, and there it's actually better the connection. Our people from IT are looking into this and are doing the best they can to make sure that you are able to follow us. Please also don't forget that we are being recorded. So I hope that if you have been missing the first few slides from Emilio, anyway, all the slides that you have seen so far will be published. So we will have them on legalfifa.com. And I hope that also somehow we'll be able to show to you the recording. Having said that, I hope that it works. And I'm very happy to present to you my next speaker. It's Erica Montemor, the head of player status, and she's here to give us an overview over the activity of the player status department, as well as the leading cases of her department. Erica, over to you. Thank you.
Thank you, Maya. Hello, everyone. It's a pleasure to be here again to present you the activities of player status department. I have to say, if something can make me more nervous than speaking in front of a live a live stream, is to follow the president and Emilio Garcia. So I'll try to do my best here. But what I want to say is that, jokes aside, that there has been a very busy year, as you see from Emilio and from the president. He showed all the programs, activities, and publications issued by the legal division. And player status department was in the middle of most of it, because it affected the regulations. And so I will give you today to show you how busy 2020 was because of COVID, but I would like to say also in spite of COVID. So here, before starting, I would like to take a moment to thank my team, to thank the Player Status Department team that really showed commitment and worked through a very busy year with all the challenges we had due to COVID. My presentation today, I will divide in two parts. So first, I will show you a review of 2020, and here basically show you the numbers in contrast with other years. And then also touch up in some of the latest amendments, the ones that will not be presented by my colleagues, so coaches, female players, and execution will be presented tomorrow, but I will pass on some important amendments that were through. And on the second part, I will present you relevant decisions adopted by the FIFA deciding bodies, the Dispute Resolution Chamber and the Player Status Committee. Okay, let's start. So we can see here in the numbers, and here we'll start with first the claims of solidarity mechanism and training compensation. They are lodged and processed via the transfer matching system, the TMS. And as you can see, in 2018, there were around 1,200 new claims lodged. If we go to 2019, we can see a 26% increase. There were more than 1,500 new claims in that year. But if we move forward to 2020, we see there was a new record. More than 2,000 new claims were lodged and processed in the transfer matching system, with a 32% increase of claims. As you can see, 2021 has also started in full power, and in the first 2 months, we already had more than 300 claims lodged, which indicates that we're going to have a busy year ahead. Now moving to the contractor disputes, here we're talking about all claims involving players, coaches, clubs, and member associations. Here as well, we can see that in 2018, there were more than around 1,000 claims lodged during that year. And in 2019, we saw there was a 20% increase, and we had 1,200 around claims lodged before either the DRC or the PSC. But then in 2020, we have witnessed a record increase. We had more than 40% of increase in the new claims, and we reached more than 1,700 new contractor disputes lodged before one of the deciding bodies. Here, I would like to refer to a particular period of time that between March 2020 and December 2020, we really saw the impact of COVID, in particular in employment-related disputes between players and clubs and disputes between clubs. As from March 2020, in comparison to the first 2 months, there was this further increase of 20%, reaching the 40% that I mentioned before. And finally, in 2021, you can see already that the first 2 months were also quite busy, indicating that this tendency is for now to stay. Now, of course, sorry, going back. If we're talking that many new claims were lodged, that also means an extra effort needed to tackle the workload and to make sure that we continue to provide the parties and the stakeholders with an efficient dispute resolution system. So here, as presented last year, so here I'm also making reference to the amounts showed last year in the FLAR. In 2018, around 1,100 decisions were passed. Of course, in 2018, with a big effort to tackle the backlog, more than 2,000 decisions were taken by the deciding bodies, the DRC and the PSC. And now, no longer we have a backlog, but as you saw, we have a really big increase on new claims, and that meant that the DRC and the PSC had again to analyze and decide on more than 2,000 decisions. So 2020, we had 2,109 decisions passed by the DRC and the PSC. So I said it was a busy year because of COVID, but in spite of COVID, we managed to continue to maintain the same rhythm and provide the parties and the stakeholders with an efficient dispute resolution system. And here as well, I take a moment to thank, of course, the members of the Dispute Resolution Chamber and the Player Status Committee for analyzing and deciding on more than 2,000 cases. Now, moving to the next topic, I would like to speak about the transfer of minor players. And here as well, as you can see, it was a busy year. The Player Status Department has dealt with more than 4,000 applications, passing almost 3,900 decisions. The great majority of the applications are still under Article 19, paragraph A, which means the move of the parents for reasons not related to football. Here again, also take a moment to thank the team, and also to say that despite the COVID, we managed to improve the efficiency and deal with the applications in a more efficient manner. Now, 90% of the cases are resolved in less than a month, and the average between the receipt of an application and a decision being taken is 12 days. As you can see also in my slide, you can notice that the time to process an application is directly impacted by the parties, meaning that whenever we need to ask for additional documentation, this application will take twice the time to be decided. So a complete claim is dealt with in half the time in comparison to the ones that we need additional documentation. So this, I would take the opportunity to refer to what Emilio has said. So he showed you the guide to submitting a minor application. And this is an important tool for the parents of the minors, the clubs, and the association, in the sense that if an application is submitted and is complete, it will be able to provide you the decision in a more swift manner. And that's why I encourage you to read the guide prepared by the team. If we continue, still about minors, is to say that we can clearly see the impact of COVID. As everybody knows, in the reports that were issued by the legal division, COVID outbreak had a concrete impact on international transfer, and obviously also in the transfer of minor football players. The images here speak for themselves. I'm sorry, I hadn't changed the slide yet. So the images here speak for themselves in the sense that the first time in history that we received less cases compared to the previous years. So there has been a steady increase of applications throughout the years, as you can see. And 2020, there's a clear impact where the tendency goes to the opposite direction. We can also see in the month by month that this continues in 2021. Since we are talking about the effects of COVID on our daily work, and again, as showed by Emilio, it was a very busy year providing service to the stakeholders, handling validation exceptions, manual transfer windows, ITC procedures, eligibility matters, and replying to many queries related to COVID-19. Luckily, we were ready to provide ongoing support during the whole pandemic to 118 member associations to change their registration periods that were affected by COVID-19 or their season dates, and also to support on release of players association teams. As the president mentioned, it took an effort from everybody together, and also the temporary amendments to make sure that the players could play for the national team. Now that we finished with the numbers, let's go to the relevant amendments. And here, as Emilio said, we had several amendments during 2020. And most of them were needed. We needed to change temporarily the RSTP to make sure that we could cope with COVID. And this basically affected exception to registration periods, changes related to the release of players, and that is the reason why 2020 was with many additions of the regulation on the status and transfer of players, which I will now refer to as the RSTP or regulations. But there is one amendment that I will speak today that will not be explained by my colleagues, which is not COVID related, but is about transfer of minor players. So in January 2021, a new amendment came into force related to the transfer of minor players. And the background of this amendment is the UK and Brexit. So as you know, UK is one country with 4 separate MAs, member associations. And there was legal uncertainty concerning the effects of Brexit and the imminence of UK leaving the European Union. So the international transfer of minors within the UK will no longer be subject to the so-called EU exception under Article 9, paragraph P of the RSTP. So this amendment to the 19, which we'll see in the next slide, aimed to exactly avoid that a minor would be unable to transfer between the same country. I would like to clarify that obviously this amendment does not apply only to the UK scenario, but to any other situation where more than one member association is domiciled in the same country. So moving to the next slide, we have the new wording of Article 19. And here we see that under Article 19, paragraph B, we have the exception that applies to transfers within the territory of the European Union or the European Economic Area, but also now, as of January 21, it also applies to transfers between two associations within the same country. Just to clarify, of course, the same obligations that existed for the clubs are applicable also to the transfer between the same country, meaning that the club must provide football education in line with the highest national standards, academic education, and accommodation. Okay, now I will move forward to the procedural rules. And here I will speak about the most relevant recent amendments we had that entered into force in January 2021. So first of all, to explain why did we amend again the procedural rules, here the amendments were to reflect the practice of the FIFA administration and the jurisprudence of the DRC and the Player Status Committee, and to provide legal certainty and more efficient service. So the first article amended was Article 9, paragraph 4, to make it clear that whenever an opposing party, meaning here the respondent, wishes to lodge a counterclaim, the club or the player or the coach, the party must do so within the same deadline given to reply to the claim. Also, this counterclaim must fulfill all the requirements to any claim lodged before the Player Status Department and needs to be compliant with Article 9, paragraph 1. On the same note, in case it is not a counterclaim but received parallel claims regarding the same contractual disputes, they will be dealt with as claim and counterclaim. This is to avoid delays or any unnecessary exchange of correspondence, as well as guaranteeing due process and obviously avoid to have controversial decisions. Now going to the next amendment is Article 9, paragraph 1, which now has a new letter, J, and it refers to the bank account registration form. And here again is also to provide a more efficient services. So as you know, since June 2018, Article 24B is applied, meaning that the decisions taken by the DRC and the PSC, whenever 24B is applied, will be executed by the player status. And already in the decision, it was foreseeing the consequences for the non-fulfillment of the decision. Well, the problem that we encountered was that to count the 45 days, we would need the information from the creditor that had notified the debtor about the bank details. So we will need this information before being able to start counting 45 days and execute the decision. For that reason, and also in accordance with the new Article 24bis, which will be explained by my colleague Molly, now the new claims as of January 2021, apart from all the requirements of Article 9, paragraph 1, also need to have this bank account registration form, which is available in legal.fifa.com. And this way, we can then pass a decision and already from the date of the decision, start counting the 45 days. And also, this will come for my next slide in the proposals. So here, another change is Article 13, which is the article that talks about proposals. As you all know, proposals were only used before for cases of solidarity mechanism and training compensation. And this was applied for cases where there are no complexity and or there was an established jurisprudence. Well, now, as of January, this is also applicable, January 2021, to cases of contractual disputes. Obviously, that means only cases of non-complexity and that has an established jurisprudence. So to put an example, for salaries that are unpaid and that are clearly established in the contract or installment of a transfer fee, in these cases, the FIFA administration can and will use the proposal to the parties. What is important is that now, whenever the proposal is possible, we will send the claim to the respondent and we will send the proposal together with both parties, and they have 15 days to either accept or reject the proposal. in case the respondent wishes to reject the proposal, should already send as well its position to the claim, because this is the same deadline to reply and do the proposal. In here, the same as for solidarity and training, whenever the parties accept or do not reject the proposal within the deadline, this proposal will be considered accepted and binding in all the parties. What is new in Article 13 as well is the fact that after this deadline, a confirmation letter will be issued to the parties and 24 bis will apply. So I think it's important for the parties are aware of that, and this will for sure bring more efficiency to us and also allow us to focus on the most complex matters to be submitted to the Dispute Resolution Chamber and the Player Status Committee. Now moving on to the part of the leading cases. So I finished with the numbers and the recent amendments. I will now speak about the leading cases. And the problem is, how do I pick the most interesting cases out of 2,000 decisions? So since the most spoken topic has been COVID, and as Emilio presented, there were many documents issued by FIFA in this regard, I decided to choose cases where the DRC analyzed the unilateral termination of a contract in connection with COVID-19. So in this first case, we have here the facts of the case. In here, there were several salaries unpaid by the club. And on 14 March 2020, the player, on 14 March in 2020, the club canceled all trainings sessions as a result of the pandemic. On that same date, the player put the club in default in writing in accordance with the RSTP and Article 14 bis, giving the club 15 days to remedy the default. The club, unfortunately, did not pay the salaries within the deadline. And following that, on 30 March 2020, the player terminated the contract, invoking just cause to do so. Subsequently, the player came to FIFA and lodged a claim for breach of contract against the club. And the club replied to the claim. But here what is interesting is that the club did not contest that the amounts requested by the player were outstanding, but the club argued that the termination was without just cause because it was done during a force majeure situation while the contract was actually suspended. So here we have the work of the DRC. The members of the DRC had a lot of cases to go through. And in cases of COVID, a lot of documents to analyze. So first of all, while analyzing whether the contract was terminated with or without just cause, the DRC first referred to the COVID-19 guidelines issued by FIFA, as well as the FIFA COVID-19 FAQs, which were presented by Emilio before. As to the force majeure invoked by the club, the chamber recalled that FIFA did not declare that the COVID-19 outbreak was a force majeure situation in any country or territory, as well as that any specific agreement was impacted by the concept of force majeure. What does that mean? In summary, translating, it means that it is the responsibility of the party invoking force majeure to prove that such situation occurred and also draw the consequences from it. And at the same time, it means that the dispute resolution chamber must analyze on a case-by-case basis, considering all the specific circumstances and the documentation provided by the parties, whether or not there was a situation of force majeure. The DRC also highlighted in this decision that the two documents issued by FIFA related to COVID-19 explicitly indicated that they were only applicable to the unilateral variation of existing agreements. That means that the guidelines are only relevant if a termination of a contract occurs following a unilateral variation of that contract. Otherwise, the unilateral termination of a contract continues to be analyzed under the RSTP and the jurisprudence of the DRC. In the present case, the DRC considered that the two salaries were, in the present case, there was no variation prior to the termination of the contract, and therefore only the RSTP applies. That being said, the DRC analyzed the facts and evidence in the case, and first of all, considered the two salaries were outstanding already before the suspension of the football activities, and the club failed to provide any justification why it did not fulfill with its contractual obligations. Also, the player had put the club in default, giving them the possibility to remedy the default in 15 days in writing in accordance with the RSTP. Therefore, the DRC concluded that the player had just cause to terminate the contract on 30th of March 2020 based on Article 14b's paragraph 1 of the regulations. The club was therefore liable to pay the outstanding remuneration to the player as well as compensate the player for the breach of contract. Here, going to Article 17 of the RSTP, first of all, the Dispute Resolution Chamber analyzed whether the contract had a compensation clause. Since the contract did not have one, the DRC calculated the compensation based on Article 17. Considering the player remained unemployed in this case, the compensation award was the residual value of the contract according to Article 17. Now I'm going to go to the second one, but I'll do a short break. Maya, how much time do I have? 10 minutes, okay. So now I'll finalize with the second case, try to be fast so we can also open the floor for questions. In this second case, we will see that the same on 16 April 2020, the club suspended the contract, and in this case also the salary payments, and referred to a national law, a national government emergency order. On that same date, the player put the club in default, notifying the club in writing, the same as the other case, and granting the club 15 days to pay the outstanding salaries. Since the club did not pay the unpaid salaries, on 4th May 2020, the player terminated the contract, invoking just cause. What we see here is, again, the player lodged a claim for breach of contract against the club before FIFA. And the club also did not contest that the amounts were requested by the player were outstanding, but in this case argued that at the time of the termination, the contract was suspended, rendering the termination without effect. The player, for his part, argued that the COVID-19 could not be used as an excuse, since the salaries that he was claiming and on the basis of which he had terminated the contract were already outstanding before the suspension. So here, I'm not going to go through again everything, just to remind that the DRC referred to the FIFA COVID-19 guidelines and COVID-19 FAQ. And as in the previous case, members of the DRC recalled that both documents only apply to unilateral variation of existing agreements. In the present case, the DRC considered that the decision of the club to unilaterally suspend the contract and the salary payments should be regarded as a unilateral variation to the contract, and therefore it needs to be analyzed under COVID-19 guideline. So both the documents are applicable here. The DRC, analyzing the documentation presented by the club, established that based on the documentation, according to the national law, it was indeed possible to suspend the contract in case of a temporary interruption. Also, during that suspension, in their emergency order, the player was entitled to receive up to 75% of his income. Also, the authorities in that country had declared a state of emergency until 31st May 2020. And finally, that the competition will resume as of June 2020. So the DRC considered that taking into account the specific circumstances of this case and all the documentation provided, despite there was no agreement between the parties, the club demonstrated that it was allowed to suspend the contract while referring to the player to the possibility to collect part of his salary from the government. But that being said, as we saw, the DRC considered that the club did not bring any valid arguments to justify why it failed to pay the salaries, which were already due before the suspension. Also, the chamber considered and accepted the argument of the player that the outbreak cannot be used as an opportunity to escape debt that fell due at an earlier stage than the actual suspension. Also, as to the argument that the player could not terminate the contract during the suspension, it was considered that this argument could not be upheld and that the club admitted not respecting contractual obligations. Therefore, in accordance with the principle of pacta sunt servanda, the club had to comply with its obligations. Therefore, the DRC concluded that the player had just cause to terminate the contract because in that moment of the termination, more than 2 salaries were overdue, according to Article 14b's paragraph of the RSTP. In the same sense, the player was also entitled to receive the unpaid salaries and compensation. What is interesting about this case, and why did I choose to show two cases on the same topic, is because in this one, there's something interesting about the unilateral variation. As we saw, the unilateral variation did not change the fact that the player had just cause to terminate the contract, but it did have an impact on the residual value of the contract. So first of all, since the parties did not agree on a compensation clause, the same as the previous case, the DRC applied Article 17 for calculation of the compensation. Since the player remained unemployed, the compensation corresponded to the residual value of the contract, which would run until June 2022. The DRC, however, considered that should not take into account the month of May 2020, because this month, according to the order of the national law, was to be paid by the government to the player. For this reason, the residual value of the contract was considered by the DRC as from June 2020 until June 2022. This decision has been appealed and it's currently a case. So maybe next year I can tell you what is the outcome and what is the analysis of CAS concerning the COVID guidelines. To finalize, and before opening questions, I just want to say that from both cases, we can draw some conclusions that has been in all the DRC meetings where we have our cases with COVID, that this is always referred by the DRC. So first of all, that the FIFA COVID guideline and FAQ did not declare force majeure in a specific country or territory, as well as needs to be analyzed on a case-by-case basis, and the party invoking the force majeure is the one that has the burden of proof. Second of all, is that the COVID guidelines do not apply to the unilateral termination of a contract, but only to the unilateral variation of a contract prior to a termination. And finally, that nothing has changed in the sense that for unilateral termination, what is applicable is the RSTP, the Regulation of the Status and Transfer of Players, and the jurisprudence of the DRC. Thank you very much. I'll pass the floor to Maya if there are questions.
Thank you very much, Erika. First, the good news. It looks like it's working again, our stream also on YouTube and on the webpage. So we, again, were able to reach around 600 people following us today. So I received a few questions. First one that I would like to share with you and pass on to Erika is coming from a Turkish lawyer. He would like to know if the application of national law depends on whether the parties chose that national law to apply to the contract.
Thank you, Maya. Thank you for the question. Here, no, I would emphasize considering what is specifically said in the COVID guidelines and FAQ, and also confirmed by the DRC, is that for the unilateral termination, it continues to apply the RSTP. So regardless of the choice of law, a national law in the contract, still for unilateral termination, we apply the RSTP. And concerning the national law would be applicable only to the unilateral variation, as we saw, because it's a specific circumstance. And as in the case that I presented, is a case where there is a national law allowing for that variation and also providing the player in that case with income while the contract was suspended. But no, national law would not apply to unilateral termination.
Thank you very much, Erika. I have another one. It's coming from a colleague in South America. He would like to know which reduction to the salary has been deemed reasonable based on the latest decisions that you have mentioned.
So I don't have a specific case here, but you saw in this one that it was a 15% reduction, and this was considered as reasonable. But this is, again, on a case-by-case basis, and it needs to be proven by the one invoking that why the reduction was made and if it's in accordance with the national law or the agreement by the parties.
Thank you very much, Erika. For the ones following us, I mean, if we look always on the side, it's because actually we are in the same room, so it's not that I'm speaking to a mirror or to someone. I know we are all alone, but we are not that crazy yet. So there is another question, and this could be maybe the last one so that we are able to be on time. I get the last one. It's related to force majeure. They would like to know if it is possible that force majeure applies as a general principle, even if the COVID guidelines do not apply.
Here again, I will have to say that it will depend really on the parties and on the analysis of the dispute resolution chamber whether or not a force majeure situation occurred. We do have many times parties arguing force majeure, but without proper argumentation or evidence. So I don't have a decision where the DRC has recognized force majeure.
Thank you very much, Erika, for this very detailed presentation of the overview of the Player Status Department and the leading cases. We will now soon move to a short break, just for you to remember to stay tuned. And after the break, we will continue with very interesting presentations of the CAS proceedings against FIFA decisions in 2020, Part 1 and Part 2. Together with Miguel and Jaime, and then we will have the entire overview about disciplinary and ethics proceedings. So please stay tuned. The best is yet to come. See you in a few minutes. Bye-bye. Welcome back after this short break. So let's start with the second part of today, where we will have some exciting presentation about the CAS proceedings against FIFA decisions in 2020. First, let's start with the leading cases, the first part. It's my pleasure to introduce my friend and colleague working here with me at FIFA, Miguel Lietard, for this first part. Miguel, over to you.
Thank you very much, Maya. Good morning, good afternoon, or good evening, wherever you're watching from. I think that's the classic introduction that we're getting used to nowadays in these online events. It's nice to be back another year with you to present the different leading cases that we've had in CAS proceedings in 2020 this time. Of course, I can't avoid starting by presenting some of the main relevant figures that we've had in this last year in relation to the CAS proceedings that went from appeals against decisions issued by FIFA's bodies. If you remember from the presentation last year, in 2019, we had 189 appeals against FIFA decisions lodged before CAS. Now in 2020, as you can see, we've almost tripled this amount, 545 appeals against FIFA decisions. This is in large part due to the backlog of cases having been eliminated in the last year. So it's part due to all of the work that was done, and of course led to a larger amount of decisions being taken. Erika just presented how many decisions were taken in the last year. And of course, we can't avoid such appeals being filed in CAS. Now, if we look at those 545 decisions, how they're split over the last years, FIFA was a party in 201 of those proceedings. So again, FIFA was a party in a larger number than absolutely total cases in 2019. And then there were 344 procedures in which we were not a party, or in which we were called as a respondent, and then the appeal was withdrawn insofar as FIFA was concerned, and therefore led to FIFA not being a party and the proceedings continuing without us. Now, I want to take the opportunity just seeing these numbers. As you can imagine, it's a larger workload that has taken place. So I want to already thank my team who has taken over a good part of this workload over the last year for all of the hard work done then. Now, when we look at what decisions were appealed to CAS in the last year, here, the distinction doesn't change much over the years. As you can see, the majority of decisions appealed to CAS still come from player status and from disciplinary. The only thing that has changed is the number of cases that have been appealed. In disciplinary, as you can see, 101 appeals against cases coming from that department, which is far more cases than we had in total in 2019, with FIFA being a party. There were 88 back then. And of course, player status follows closely insofar as FIFA is a party to proceedings, but as I mentioned before, there's still the 344 cases in which FIFA was not a party, which also came from that department. That's for decisions from the player status department and decisions from the dispute resolution chamber. Now, if we take a look at the awards that were received in 2020, we've received 57 awards on the merit, all of them published, or if not all, they will be published in the next update on the legal.fifa.com. I'm sure that many of you have already had the chance to go through them. And we've also had quite a number of either termination orders, awards on cost, or consent awards based on either that proceedings did not go forward in CAS, or appeals were withdrawn, or settlements were reached between the parties. But as you can see, of the 57 awards on the merits, of course, as is logical, the large majority relate to cases that began in 2019, some in 2020, which were able to be resolved within the same year. But we've also had some decisions, some final awards on the merits notified from cases that had begun in 2017 and in 2018. So it's good to also be closing up that other backlog of cases in itself. As to the results of the cases when those awards were received, of those 57 awards that I mentioned that you saw in the previous screen, in 82% of the cases, the appeals were either dismissed or partially upheld. By partially upheld, I, of course, refer to either CAS in disciplinary cases or ethics cases confirming the violations, but amending the sanction because of issues of proportionalities or other pertinent legal issues, and in cases arising from contractual disputes from player status. In the large majority of cases, the appeals were partially upheld in relation to the horizontal dispute between the clubs or between the clubs and the players, in which the amount in dispute was amended without affecting FIFA's position in the framework of that arbitration. If we compare with what we had the previous year, the numbers are more or less the same insofar as appeal dismissed or partially upheld, but we've also had in the last year a larger number of appeals declared inadmissible. As for those that were upheld, as you can see, we also have a mention, half of those cases were based on new evidence that was produced within the framework of the CAS appeals proceedings, those related to cases involving the transfer of minors, in which in some occasions not all of the evidence is presented to our committees and is then presented to CAS on appeal. So now I turn to the focus of today's presentations after having gone over the different statistics, and we're going to present a couple of cases here. My colleague Jaime will then follow me with a few more cases as well, of the main or most relevant ones that we've been able to see in this year 2020. And we'll start with, first of all, the case of Mr. Karamuddin Karim, whom, as you may recall, was the president of the Afghan Football Federation. Mr. Karim was accused of, over the course of several years from 2013 to 2018, of having abused his position of power to sexually abuse and violently abuse players of the women's national team of Afghanistan, as well as employees of the Afghan Football Federation. He at least raped 2 of those women, and even went as far as enabling similar abuses being carried out by other officials employed by the Federation. So in November 2018, some of the women players of the Afghan women's national team spoke to the media about those abuses, and in part that led to a twofold investigation. On the one hand, the investigatory chamber of the FIFA Ethics Committee initiated a preliminary investigation into those accusations, and in parallel, the Afghan Attorney General's office also opened its own investigation. In both of those instances, interviews were carried out with the relevant players, victims of Mr. Karim. In the framework of the FIFA investigatory proceedings, Mr. Karim was firstly imposed a provisional ban from football-related activities. Then the preliminary investigation continued until April, where a formal investigative proceeding was initiated and led to the issuance of a final report, leading in turn to the opening of adjudicatory proceedings. And then in June 2019, a decision was issued by the FIFA adjudicatory chamber, as you likely already know, banning Mr. Karim from football-related activities for life. Now, I want to focus, even though there are several legal issues that are quite interesting from this case, I want to focus on a number of them which we found interesting to analyze, but most importantly, which were quite exceptional in such circumstances. We're talking here of a case which is very fact-oriented, which is based on several victims coming forward and denouncing the abuses that they have suffered. These came forward first, as I mentioned, to the press, also to the Ethics Committee and to the Afghan Attorney General's office. And because of the particularities of this case, we asked the CAS panel to allow their examination on an anonymous basis. I will try not to go into too much details of that, even though we will see some slides of this, because I know part of this will also be covered by my colleague Mario Galabotti in his presentation later today. But in sum, what we ask CAS is to allow the questioning or the examination of witnesses under modalities that had been used in prior cases, in those cases in particular related to match fixing, the Poveda case and the Skenderbeu case, which you can see on the screen, and the CAS panel accepted to this. So one of the interesting points in this particular case was that the panel had to strike a balance between the interest of the appellant in his appeal and to preserve his right, and also the right of the victims and their protection. So the first thing that the panel ordered was for FIFA to ensure that on the day of the hearing, the victims who were going to testify would be in a location in Switzerland. So FIFA had to ensure their presence in Switzerland. This was to allow that a CAS counsel could be present with them for two main reasons. The first, to verify their identities, and second, which would only be disclosed, of course, to that CAS counsel and to the panel, never to the appellant. And secondly, to ensure that they would provide testimony without any undue or external influence. And then a positive thing that we commend the panel for accepting was allowing a full team of support to be present also with the witnesses at the time of the hearing, which included a psychologist, an interpreter, and also FIFA representatives, as well as a lawyer of the victims who was there to ensure all of their rights were protected, knowing that there were also proceedings being carried out in their home country. Another issue that the panel took into important consideration was the issue of questioning, how the victims would be questioned, what the modality was. We requested not to examine the witnesses in direct examination and asked the panel to consider the content of their witness statements as evidence in chief, for the sole reason of not making them relive those traumatic experiences that they had gone through in the past with Mr. Karim. So the panel accepted this and allowed for the witnesses to only be cross-examined by Mr. Karim's counsel, but first asked to see the questions that would be posed and made sure to guarantee that no questions would be asked to the witnesses that would allow their identification by Mr. Karim or his counsel. And then the question comes as to whether this anonymous witness protection was actually necessary. Now, under these circumstances, I've mentioned before, it's a modality that is not often used in CAS proceedings. I mentioned 2 prior cases. I know that there have been a few more, but it's not a usual way of questioning witnesses. In this particular case, the main issue that led to accepting their testimony on an anonymized basis were the threats to their lives and to their personal safety. I mean, we have to remember that they were victims of very serious crimes, not just abuses going as far as raped, committed by a very powerful person, one of the most powerful person in Afghan football, but also a very powerful person politically in his home country, a person who threatened many of them, both physically and verbally, and also threatened at least one of them at gunpoint. So these victims who, because of all of those threats and the fear to their lives and their families' lives, had to flee their country, and were granted asylum abroad, which it's important to note is not given lightly. It's always given when there's a legitimate fear of persecution from someone in particular. These victims had to be protected and their full anonymity had to be ensured in the framework of these proceedings. And the panel found that it did not have any reasons to ignore those fears when balancing it with the threats that the victims were exposed to. So there the appellant has to strike this balance on the one hand between the appellant's right to be heard and his right to a fair trial, and on the other hand, the need to protect those victims and the interests of the victims of not being identified. And it did so by several measures. I mentioned before, having a cast counsel on site, ensuring that they were identified properly in order to guarantee for the appellant's sake also that those were actually his accusers in themselves, but also by giving Mr. Karim the opportunity to cross-examine all of them in compliance with Article 6, Paragraph 1 of the European Convention on Human Rights. And then another issue comes when you consider this kind of testimony, which again takes place with the witnesses away. You don't see that person, you hear that person with a scrambled voice, so you can't identify the person. So the question that the panel had to consider is whether their testimony was actually credible, was it reliable, and what can be inferred from that testimony. And so the panel first found that there was no evidence that those witnesses would have any reasons or undisclosed personal reasons to accuse Mr. Karim beyond, of course, what they had themselves suffered in order to coordinate their own stories. In other words, each of those victims testified individually as to what they themselves had gone through. And all of them were consistent completely with the different testimonies that they had provided to the Ethics Committee and also to the Afghan Attorney General's office, and even, I would add, to what they had said in the press at an earlier stage. And again, the players had exposed themselves to and their families to social stigma and possible retaliation from a very powerful person. So going there, giving that evidence was considered as granting them even further credibility within the framework of the proceedings. And the panel, based on all of that, found that it was comfortably satisfied that Mr. Karim had indeed during that period sexually harassed and abused at least 4 of the players who had provided testimonies, and even on one occasion had gone as far as raping one of them. And the panel also was satisfied that these abuses were generally committed either in the upper office of the new AFF headquarters, or also in a secret room in behind the president's office in the former or the old building of the Afghan Football Federation, which was only accessible through fingerprint scanning. So in sum, the panel found in this case that Mr. Karim had indeed violated Articles 23 and 25 by failing to protect the physical and mental integrity of the victims, and also by abusing his position and imposed, as I mentioned, or confirmed the lifetime ban. I know Mario will go into more details of these specific provisions later on. I don't want to finish this particular the presentation of this particular case without thanking everyone who helped and who provided support in this case, and most importantly, for the bravery of the victims who came forward to tell their story. And now we go to the second case that we're going to look into. This time it's a contractual dispute of an international nature. So to give you a little bit of context, a little bit of background, this is a Brazilian player, Ailton José Almeida, who signed an employment contract with the Emirati club Al Jazeera from 15 January 2017 until 30 June 2017. The contract was at some point terminated through a settlement agreement, which provided for payment to be made by the club to the player in 4 installments, with an acceleration clause, meaning that if one of the payments were not made, the player could request all of the further installments immediately, with a penalty clause with interest. Relatively, I would say, classic things. The most important part, insofar as this case is concerned, is the jurisdiction clause in the settlement agreement. As you can see on the screen, the parties agreed that any dispute arising or related to this settlement agreement would be submitted to the Court of Arbitration for Sport. So after the settlement agreement was signed, first installment was paid timely, the second was paid with delay, and therefore the player triggered the acceleration clause and filed a claim against the club before the dispute resolution chamber in March 2018. Before we go into what the decision was of the dispute resolution chamber, it's important to recall the legal framework that we're working with, particularly Article 22 of the Regulations on the Status and Transfer of Players, or RSTP, which establishes that there's a right of any player or club to seek redress on the one hand before a civil court for employment related disputes, or on the other hand, when it's a case between a club and a player of an international dimension, before an independent arbitration tribunal that has been established at national level. So the focus of this particular case will go around this provision. Now, in the DRC proceedings, the player filed his claim, requested the entire amount under the settlement agreement, and said that the jurisdiction clause under Article 8.2 of the settlement agreement was not applicable. Again, that clause established the direct jurisdiction of CAS, and instead asked the DRC to apply Article 22b, saying that this does not mention CAS as an exception, and therefore the DRC should be competent. In its answer, the club acknowledged that it had had financial difficulties in paying the amounts owed, and at the same time contested the jurisdiction of the DRC, asking that the DRC apply Article 8.2 of the of the settlement agreement, and state that CAS was the only competent body. In its decision, DRC decided that the claim was inadmissible because CAS was competent. And why did it decide this? First of all, the DRC observed that the claim was based on the settlement agreement only, and asked or evaluated whether Article 8.2 of that agreement should apply. Now, the DRC noted that the jurisdiction clause there is clear and is specific in favor of CAS. It simply says any dispute will be submitted to CAS, to paraphrase the wording of the settlement agreement. So there, the DRC found that the principle of choice of forum, being a fundamental right of the parties, led to it being sufficient to broadly interpret Article 22b, paragraph B of the RSTP, saying that it's sufficient that the chosen forum respects the principles of due process like an ordinary court. That was the finding of the DRC. And the DRC, of course, confirmed that CAS does respect the fundamental principles of procedural law, as confirmed on several occasions by the Swiss Federal Tribunal. And therefore, the choice of the parties in the settlement agreement under Clause 8.2 of submitting disputes to CAS had to be respected, and as a consequence, the DRC was not competent and declared the claim inadmissible. Now, going back to CAS, the main issue in dispute was whether the parties had validly chosen CAS and thereby excluded the FIFA Dispute Resolution Chamber to resolve its dispute in relation to the settlement agreement. And the question was that whether the validity of Article 8.2 had to be assessed within the applicable regulatory framework. In other words, in line with the FIFA regulations. And then in this case, the sole arbitrator considered that there had to be an interpretation of the FIFA regulations carried out, and considered that in order to interpret the particular provisions or agreed upon by the parties in the settlement agreement, they had to use the different methods of interpretation established by CAS jurisprudence as well as by the Swiss Federal Tribunal, which are, of course, the literal interpretation as a starting point, so the actual literality of the clause, the teleological interpretation, in other words, taking the purpose of the rule, in this case of Article 22 of the regulations, into account, and then we go to the systematical interpretation, so taking all of the other legal provisions and the regulatory context into account. So those are the three main methods that were applied or considered in this particular case without need to go into the historical interpretation. So in this case, first, analyzing the literal interpretation or the literal wording of Article 22, the sole arbitrator found that it's rather self-explanatory. And from that particular wording, it's not possible to argue that the objective of the rule is to give the parties the liberty to choose a forum other than FIFA with the sole limit of the respect of the fundamental principles of law. So with the literal interpretation, you could not reach the conclusion that had been reached by the DRC. Then the sole arbitrator looked for the intention, so going towards the teleological interpretation of the rule, and referred to the FIFA commentary, which generally provides some clarity and will provide more clarity when the new commentary is published soon enough, and found that in the actual version of the commentary, there's no indication for a different interpretation assimilating CAS to a civil court for employment-related disputes. So to that first exception foreseen in Article 22B of the regulations. In other words, CAS is not a civil court, and therefore you cannot widely interpret that first part or that first sentence of Article 22 of the regulations. And also, the sole arbitrator took note that CAS is neither established at the national level, and it's not established within the framework of an association, as mentioned in Article 22, paragraph B. Therefore, the sole arbitrator found as a preliminary note that following the literal or the teleological interpretation, the validity of Article 8.2 of the settlement agreement could not be established on the basis of Article 22 of the regulations, and therefore had to go one step forward. And in order to ascertain the true intentions of the legislator, it was necessary to analyze the regulatory framework of Article 22 of the RSTP. And in that particular case, the sole arbitrator noted that the jurisdiction of the dispute resolution chamber is governed by the regulations on the status and transfer of player, but in accordance with Article 46 of the FIFA statutes. And that this provision and any norm of the same hierarchy as that provision in the FIFA statutes also had to be considered. So the arbitrator first went to recall the legal framework in the FIFA statutes with respect to the Court of Arbitration for Sport. As you know, according to Article 57, FIFA recognizes CAS as an independent body to resolve dispute between FIFA, member associations, confederations, leagues, and insofar as this case is relevant, clubs and players. Then Article 58 of the FIFA statute provides for the jurisdiction of CAS in appeals against FIFA decisions and against final FIFA decisions, with certain exceptions foreseen in Article 58, paragraph 3, which stipulates which kind of cases CAS does not deal with, among others, violations of the laws of the game, suspensions of up to 4 matches, etc. Then the sole arbitrator turned to the obligations that are imposed in the statutes on member associations insofar as dispute resolution is concerned. And in this case, the sole arbitrator recalled that confederation, member associations, and leagues have the obligation of agreeing to recognize CAS as an independent judicial authority. And insofar as disputes are concerned, under Article 59, paragraph 3 of the statutes, associations have the obligations of inserting a clause in their own statutes or regulations stipulating the jurisdiction of CAS, specifically to deal with, among others, disputes affecting leagues, members of the leagues, clubs, players, etc. So disputes of the nature that we're dealing with or that were dealt with in the case at hand. But most importantly, there's an obligation of the member associations to ensure that those disputes are taken to either an independent and duly constituted arbitration tribunal recognized under the rules of the associations or of the confederation, or to CAS. So CAS jurisdiction is foreseen within the obligations of member associations in the regulatory framework at the local level. So considering this systematic interpretation, the sole arbitrator found that Article 57, paragraph 1 of the statutes stipulates that CAS is recognized as an independent adjudicatory body for disputes between clubs and players without any limitation whatsoever. There's no limitation in that particular provision. Conversely, Article 59, paragraph 3 of the statutes, which we just saw, forces or obliges associations to recognize CAS and to ensure that those disputes are not submitted to ordinary courts, but rather to dispute resolution chambers recognized at the national level or to CAS specifically. Then if we turn to Article 58 of the statutes, this provision does set limits to CAS jurisdiction, as I mentioned before, but only for appeals, cases of appeals proceedings, in other words, appeals against FIFA decision, but it does not establish any limitation for CAS as a first instance tribunal. So the only limitation to CAS as a first instance tribunal remains the one foreseen in Article R27 of the CAS Code of Sports-Related Arbitration, which establishes that disputes submitted to this court must be sports-related or related to sports. So again, according to the sole arbitrator, Articles 57 to 59 of the statutes would lead to conclude that the choice of forum clause in the agreement and the settlement agreement was valid, and that the potential interpretative conflict between Article 22b of the regulations has to be resolved by using the principle of normative hierarchy. And in this particular case, sole arbitrator found that Articles 57 to 59 of the statutes have to prevail, that the arbitration clause between the club and the player is fully valid, and confirmed the decision of the DRC to declare itself incompetent to deal with such dispute. In other words, it confirmed that FIFA did not have jurisdiction to deal with this dispute. On the other hand, the sole arbitrator also found that he could not address the merits of the disputes in themselves. That was an alternative request made by the player in his appeal, stating that even if the sole arbitrator, or asking that even if the sole arbitrator were to confirm that FIFA did not have jurisdiction, that the CAS should then deal with this matter in first instance within the framework of this appeal. In this particular case, the sole arbitrator found that it was not possible for him to deal with this sort of appeal or this sort of dispute within the framework of the appeal, because the dispute had to have been filed within the framework of an ordinary arbitration proceeding. And here the scope of review was limited to whether or not the FIFA DRC had jurisdiction to decide on the dispute between Al Jazeera and the player. So what takeaways can we gather from this particular case? The first is that Article 22b of the regulations on the status and transfer of player has to be read together with the FIFA statutes. And now, as a result of this case, possible exceptions to the competence of the DRC are not just civil courts, as in the preamble of Article 22 of the RSTP, and not just national dispute resolution chambers established at the national level and recognized by the member associations, but also CAS constitutes an exception that allows for the parties to settle their disputes and therefore withdraw from the jurisdiction of the FIFA dispute resolution chamber. And the other takeaway that we can gather from this particular case is that the provisions of the FIFA statutes are superior regulatory force and therefore supersede the provisions of the FIFA regulations on the status and transfer of players in case a comparative analysis between them leads to contradictory results. So if comparing between the RSTP and the FIFA statutes leads to contradictory result, according to this CAS award, the provisions of the FIFA statutes have to prevail. In other words, in this particular scenario, the principle of lex specialis derogati lex generali is not applicable to the RSTP in respect of the statutes which are of a higher norm. So, I mean, in my opinion, this is quite an interesting award, and so far mainly for the first takeaway that we have on screen, which is the recognition of CAS as an independent arbitral tribunal that allows to withdraw from the FIFA jurisdiction under Article 22b. So this would lead to, in principle, our dispute resolution bodies from not accepting its jurisdiction in cases in which the disputes have been submitted exclusively to CAS, as was the case in this case at hand. It's also interesting, but on a positive note as well, that as you recall, for the last almost year and a half, almost 2 years, now the FIFA disciplinary code foresees the possibility of filing complaints in relation to the non-compliance of ordinary arbitral awards issued by CAS. So that also leads to the possibility of these disputes being submitted to CAS, to the detriment, in this case, of the FIFA dispute resolution bodies, but then being enforceable before the FIFA disciplinary committee. So I think this is it for my presentation. I don't know, Maya, if there are any questions.
Yes, they are. Thank you very much, Miguel, for this very detailed presentation. We have some questions. I received one from a South African lawyer, and it's connected with the Karim case. The lawyer would like to know how long was the preparation procedure until the conclusion of this very difficult case, and how many lawyers of your team have been working on that case?
Thank you, Maya, and thank you for the question. The preparation for this case, the appeal was filed, if I recall, in August of 2019. The decision was from 8 June 2019. I mean, I know there was a lot of previous work within the framework of the ethics committee as well, but when the case came to CAS, August 2019, there was quite a number of preparation involved, among other several discussions as to how to move forward, coordination to also understand the particularities of this case. I mean, this case, I think, is the first one that fell on my desk when I joined FIFA a year and a half ago. So there was a lot of getting up to speed with the specific details. We had a large number of members of, we were at least 3 lawyers directly involved in the preparation of this, and also with the support of several other members of the FIFA team and staff for the different preparatory meetings in itself. Then at the hearing, there were 2 of us, and then on the day of the closings, there was a 2-day hearing. So we were 3 on the second day, 2 of us on the first day, and as you saw in one of the slides, there were 2 FIFA representatives within the support team of accompanying the witnesses in their testimony in the location in Switzerland. So it was quite a huge team effort, not just from the litigation team, but also from the different departments that were involved in one way or another in this case.
Thank you very much, Miguel, for that answer. I still have maybe 1 or 2 more questions that I am receiving. I got one from a Polish lawyer. He would like to know from you, as the director of litigation, which are the advantages that you deem that there are in view that FIFA has now a litigation department to deal with all these CAS procedures?
Thank you for the question. There are many advantages and also some, of course, disadvantages in this case. The main advantage that I see is having a centralized point of communication with CAS, of coordination of the different CAS cases, and also managing to have a team specialized in different areas and in the different areas of law that affect our own regulations. So not just limited to player status cases, institutional governance cases, disciplinary cases, but a team that is multidisciplinary in that sense, that is capable of dealing with each or any different kind of issues that may arise. But again, the main benefit is having this centralized communication or direct communication from the CAS. So having one single point of contact within FIFA with the court, even if then in some cases and many cases, there is some coordination to be made with the different departments, of course, because as we saw at the beginning, the decisions don't come from just one department, but several departments have decision-making bodies that then lead to appeals to CAS. So there's a lot of internal coordination, but having it all together in one centralized part is, I think, one of the better parts of having this kind of a department.
Thank you, Miguel. I just received another one in connection with the second case that you presented, and it's coming from a lawyer in China. The question is whether, with the case mentioned, if there will be an agenda to adjust the contradiction of the FIFA statutes and the RSTP.
I don't know if there would be an actual change to the regulations insofar as this interpretation made by CAS, if it's something that is reasonable and which seems reasonable as constituting an exception to Article 22B, if this interpretation is accepted by the different stakeholders in general through CAS jurisprudence, I think there might not necessarily have to be a regulatory change, but that's something I imagine will also be evaluated by the relevant team in charge of this. And we don't know if there will be more cases in which maybe this particular award or the conclusion of this award that I presented would be challenged, and maybe a different conclusion could be reached. We never know that, but it's something to at least consider whether there is a need or not to amend the regulations in this respect.
Thank you, Miguel. And here the last question that we have received, and it's in connection with the languages in front of CAS with Spanish. A lawyer would like to know if, with the inclusion of Spanish as a language in front of CAS, if this has had any increase in cases before CAS, in your view.
Thank you for that question. I feel like there were already quite a number of cases in Spanish that were being filed in CAS beforehand, and that we've continued, or that we've agreed to maintain Spanish in itself, or we would generally agree to continue with a case in Spanish even before the change of regulations. Ironically enough, I feel like since the change in the regulations, we're getting more cases in French for some reason, but I think the amount of cases in Spanish generally has stayed more or less the same, which was quite high in itself. What may be a bit different maybe is that there's less of a dispute when there are multiple parties involved, and with different languages, there might be less of a discussion as to whether Spanish or not should be the language of the arbitration, or at least it pushes the parties to agree to bilingual arbitration and including the submission of written submissions, documents, evidence in Spanish as well. So maybe that's something that has increased, is more a number of cases in which Spanish is either the co-language or the same language or the primary language as well. And if that's it, there are no more questions.
There are no more questions, but
right.
If you would like to say anything back the camera, please, to Miguel.
All right. I will just say, as a one last thing, just to all my usual suspects, opposing counsels, CAS arbitrators, CAS counsels, I'm sure I'll see you all soon enough by video, but I really do hope that we'll have the opportunity of seeing each other in person very soon. And lastly, because the timing somewhat works, even though a little bit in advance, happy birthday to my mom. Thank you.
Thank you very much, Miguel, for this nice closing. And also then from our side, from the FLAR part administration, we wish your mother tomorrow also a very nice birthday. Before we continue with our next speaker, for those of you joining us maybe only now or rejoining us, a few administrative points. You can follow us not only in English, but also in French and Spanish. You will be able to download all presentations that you have seen so far within the next days on the Legal FIFA. And there will also be the recordings in the 3 languages, Spanish, French, and English on the webpage. So for once, also my mother will be very proud to see that I'm fluent in French. Having said that, I move to my next speaker, which is here with us today to present us the second part of the leading cases in CAS proceedings against FIFA in 2020. It's the head of litigation, my friend and colleague, Jaime Camberlain Contreras. Jaime, over to you.
Thank you very much, Maya. Hello, everyone. As I think every single speaker is going to say, good morning, good afternoon, good night to all of you watching all over the world. And thank you, Maya, for the nice introduction. As you have mentioned, I'm going to be speaking about more leading cases that we have received during 2020. Of course, there are many other awards that you can find in FIFA.legal.com, showing the diverse work that we have been carrying out this year in the litigation department. I would also like to thank the team, Melanie, Marta, Erika, Roberto, Saverio, and Alex, for the great work that they have carried out during 2020. Having said that, we can move on to the first case that I will be presenting today, which involves the Football Association and FIFA. This is a case of a disciplinary nature concerning the provisions on the protection of minors contained in the regulations on the status and transfer of players. For those of you maybe not so familiar with football, the Football Association is the member association of FIFA that runs and governs football in England. So before analyzing the CAS award, we need to look at the background. How did this case come to life? Well, it all started with an investigation on certain minor players, over 150 minor players that had been investigated in relation to the English club Chelsea. So with this investigation, two cases were triggered: the case against Chelsea and the case against the FA. In order to understand part of the reasoning of the award concerning the FA, we need to first look at what happened with the Chelsea award. And basically, on the 18th of February 2020, there was a CAS award where the sanctions initially imposed by the FIFA Appeal Committee were reduced. One of the reasons why it was reduced was that the panel of the sole arbitrator in that case, with information at his disposal, considered that the Premier League games program, the PLGP, as I will be referring to it during the presentation, was considered as not organized football. Okay, you might be asking yourselves, what is the PLGP, what is organized football? We will go into those concepts throughout the presentation because those were part of the core of the analysis that the panel in this award had to undergo. So now we go to the second case that was triggered by that investigation, the case of the FA. Here, as you can see from the slide, after a first decision of the disciplinary committee, the appeal committee passed a decision upholding partially the first instance and still maintained a considerable fine against the FA, together with an obligation to regularize the regulatory framework in England applicable to minors. And you can see on the slide that I highlighted the date of the hearing at CAS, 26 June 2020, because by that date, the parties and the panel had access to the award on Chelsea. So the first question that the panel had to solve was basically what was the effect of the Chelsea award with respect to the dispute of the FA. So basically, if the Chelsea award deployed res judicata effects over the dispute with the FA, or basically in even simpler terms, if what already had been decided in the Chelsea dispute could be binding and should be applied also in the case of the FA. The panel, well, the parties said the following. The FA was of the opinion that yes, the Chelsea award has to be applied, while FIFA, we defended the opposite, that CAS awards do not have binding effects. And the panel agreed with us on this point because it stated that the Chelsea award only has res judicata effects in the dispute between Chelsea and FIFA. But in the dispute between the FA and FIFA, that award did not have any binding precedent, any binding value. And therefore, FIFA was able to relitigate issues that had already been decided in the Chelsea award. Once the scope of the panel's analysis was already confirmed, then it was the moment to analyze on which basis can FIFA member associations as the FA be sanctioned when it comes to the provisions on the international transfer of minors. Well, the first one, and the panel identified a double liability. The first one is Article 14.1, paragraph D of the FIFA statutes, which basically establishes that the FA has to make sure, as any other member association, has to make sure or cause its own members, its clubs, like Chelsea in this case, to comply with the provisions regarding minors in the RSTP. And the panel confirmed that this is not a question of strict liability. It is not because Chelsea is sanctioned that the FA will automatically be sanctioned. But if the FA is charged by FIFA, then the member association has to show that it took all reasonable steps in order to demonstrate that it complied with its obligation under 14.1D. Then that's the first basis for liability, but then the panel also identified some other provisions in the RSTP, like Articles 5 and 19 bis, which impose direct obligations on the associations. Once this is clear, once we know what the basis for the liability is for member associations, the panel focused on Article 5. Article 5 concerning registration, and in particular, I draw your attention to the sentence that is highlighted, which says basically that only those players that have already been registered with a member association can participate in organized football. The question here is, what is organized football, right? And this is precisely the next point that the panel had to answer. When looking at the concept of organized football, the panel obviously looked at the definition of this term in the FIFA regulations, in the RSTP, which is, as you can read, association football organized under the auspices of FIFA, the confederations, and the associations or authorized by them. Because the concept of organized football starts also in turn with the concept of association football, then the panel looked at this second concept. What is association football? Which is, in short, the game controlled by FIFA and played in accordance with the laws of the game. But then the panel also saw that one of the objectives of FIFA in Article 2 of the statutes is to control every type of association football. So therefore, the overall conclusion of the panel was that organized football is not just that kind of football that is played in strict compliance with the laws of the game, but also other types of association football can be comprised therein. Now, this might be a bit difficult to understand in a presentation like this one, so the following diagram that I will show represents in a more visual way the different types of matches that are mentioned throughout the regulations and that were mentioned throughout this award, and which, in my opinion, give a good overview of how to understand this concept. So first we have official matches, which are defined in the definitions 5 of the RSTP. And then we have friendly matches, which by definition also would be the contrary or the opposite of official matches. Now we have the broader concept of organized football, which will cover every single official match and some friendly matches. Which friendly matches? Well, precisely those that are authorized or organized under the auspices of FIFA, a confederation, or a member association. All the rest of friendly matches that are not within organized football, trial matches mentioned in Article 9.2 of the RSTP, and any other sort of privately arranged match would fall under the broader category of non-organized football. Hopefully, with this diagram, there's a clearer picture and a clear understanding of what organized football actually covers. So the next question was, is the PLGP organized football? The PLGP, let's recall, it's the Premier League Games Program, which is nothing else than the framework under which youth football takes place in England. This is more than 6,000 matches that take place in a different variety of tournaments and events, and it covers all age ranges in England. So the FA defended that the Chelsea award confirmed that the PLGP is not organized football, and also for other reasons maintained the same opinion. FIFA, on the other side, still maintained that the PLGP should be considered organized football. So what were the conclusions of the panel? If we go back to the diagram that we just saw, the panel located the PLGP in the circle of organized football. And why did it do so? Well, first, it did so despite the fact that the Chelsea award had decided differently, which is one of the interesting points of this award. And in any case, the panel looked at what is behind the PLGP. It saw that there is a sophisticated structure behind it. It saw that there is a very detailed regulatory framework behind it. It saw that the business rationale of the PLGP is to produce talented football players for English clubs, and that these English clubs will be benefiting from a sporting and also financial point of view if they get to transfer those players, or even in terms of training compensation or solidarity contribution. The panel also took into account that the Premier League that runs the PLGP falls under the auspices of the FA. And in addition, the PLGP at the very beginning was created also with the assistance and with partial funding of the FA, which therefore means that it had the help and support of the FA, because help and support are part of the definition of auspices. And in turn, the terminology of auspices is also embedded in the definition of organized football. The panel reached this conclusion. And finally, even if it is true that some matches, normally of the younger categories of players of the PLGP, are not played in strict compliance with the laws of the game, because of the panel's conclusion that there is more than one type of association football, then the PLGP had to be considered as organized football. With this conclusion, then, the panel could analyze whether there was a violation of Article 5. And the panel confirmed that this was the case, because out of the 40 minor players that had been part of the investigation with respect to Article 5, the panel found that none of these players that had already participated in organized football in the PLGP had ever been registered with the FA. So basically, the panel confirmed that the violation of the FA was due to its incorrect understanding of the concept of organized football and how it applied it with respect to the PLGP. And it also became evident to the panel that the FA never or rarely checked that if Chelsea had complied with this rule, because FIFA was able to locate and to conclude that there were violations, while the FA, that had a closer connection to the club, did not manage to find such a breach. Therefore, the violation of Article 5 was confirmed, and after looking at Article 5, the panel considered that it was unnecessary to look at the other violations that the FIFA Appeal Committee had also taken into consideration, specifically the breaches of Article 19, which is the main provision on the protection of minors, and also of Article 9. Why did the panel consider that it was unnecessary? Well, because the rationale behind it is if Article 5 is the last step of the whole process in the international transfer or in the first registration of a minor player, then all the other violations would follow. And in any case, with the violations that have already been confirmed, there would be no impact with respect to the sanctions that were ultimately imposed. Again, in a more visual way, if these are the steps that have to be followed in an international transfer of a minor player, and as you see, the last step is the registration before there can be a participation in organized football, then, according to the panel, it is unnecessary to analyze the other violations. The panel did anyway look into one point related to Article 19, which is whether this applied to players under the age of 10 or 12. The panel looked at Article 9.4 of the RSTP, 19.1, and also at FIFA Circular 1468, and in line with the majority of the awards previously passed on this topic, confirmed that indeed the prohibition on the international transfer and first registration of minors applies to all different ages under 18. And therefore, because the FA failed to ensure that Chelsea was actually complying with this, it considered that the Football Association had breached Article 14.1d in conjunction with Article 19. Lastly, with respect to the violations, the panel looked at Article 19 bis 3 concerning the academies, which, as you might remember, imposes a direct obligation on the associations. Well, in this case, the panel considered that the direct obligation in this case, which is to keep a register of all minor players attending clubs and academies in this case in England, is a direct obligation that cannot be delegated to anyone else. It cannot be delegated in this case to the Premier League. And therefore, by not having or by failing to keep its own register, the FA was considered to be in breach of Article 19(3). And in addition, because the FA did not run compliance to verify if Chelsea was actually reporting those minors in order for the FA to keep that register, then there was also a violation of Article 14(1)(d). Lastly, the panel confirmed the sanctions imposed on the FA. It also gave the indications as to what the FA had to do in order to fall in line with the provisions on minors in the RSTP, and confirmed, as I said, the fine imposed by the FPL committee, but it made it subject, or half of it was made subject to a probationary period. Okay, this is it for the first case, the case of disciplinary nature. And now we can move on to a second case, which concerns an employment-related dispute between all the different parties that you can see on the screen. Well, before going and diving into the award itself, we need to understand the facts that led to the dispute. So the facts concern mainly this player, Mr. Saman Ghoddos, a successful Iranian player that, as you can see from the Panini sticker, participated in the FIFA World Cup in Russia 2018. And as you can see also from the bottom of the sticker, this player was under contract at that time with Östersund, a Swedish club. So after his great performance in the World Cup, many clubs in Europe start asking and inquiring about the player. They start contacting Östersund. One of these clubs was Huesca, and obviously another club was Amiens. So Huesca and Östersund start exchanging emails, and to the extent that on 7 August 2018, the player is authorized to travel to Huesca. And on that same day, Östersund even accepts an offer via email of Huesca. The offer basically was 3 million euros and a 20% sell-on fee for the permanent transfer of the player. On that same day, after the acceptance via email of the offer, Huesca sends a draft transfer agreement. On 8 August 2018, so the following day, because the player was already visiting the city, visiting the club, he was in Spain, the club, Huesca, and the player sign an employment contract. But when the player tells the president of Östersund that he had signed an employment contract, the president of Östersund tells him to immediately return to Sweden because, in his opinion, he had never allowed him to sign such a contract. So 4 days afterwards, on 12 August, the player actually plays an official match with Östersund. Then Huesca, in the meantime, asks Östersund to return the draft transfer agreement, signed or completed, which never happened. And on the 18th of August, the player sends a letter to Huesca saying that he's terminating the contract because he was misled into signing it, because he didn't know that he was signing an employment contract. Well, on the 22nd of August, 4 days later, Östersund transfers the player to Amiens, to the French club, for 4 million euros, so 1 more million than what it had already agreed with Huesca. And the player and Amiens sign an employment contract on the following day. This is basically the whole background, factual background of the dispute. So with all these elements, the FIFA DRC decided that the player's employment contract with Huesca was valid and binding because it could not be made subject to a transfer agreement being concluded or not. The player was deemed to have terminated the employment contract without just cause, and therefore he was ordered to pay 4 million euros to Huesca as compensation for breach of contract. And when analyzing how or which club had to be jointly and severally liable between Östersund and Amiens, it was actually Östersund who was considered to be the jointly liable club. And in reaching this conclusion, the DRC stepped away from the literal interpretation of Article 17.2 and understood that it had to identify which one was the club that was benefiting from the breach of contract. In this case, obviously, Östersund received 1 more million thanks to this breach of contract, and therefore it was declared as jointly and severally liable. Then sporting sanctions were imposed on the player and on Östersund, and Amiens was never ordered to pay any amount. This decision was, as you all can anticipate, challenged before CAS, and therefore when it came to the CAS panel to decide, before going into the merits, there were 2 procedural issues that had to be resolved. The first one, whether holding a hearing by a video conference would constitute a violation of the right to be heard. We are now very much aware and very used to holding hearings almost exclusively by a video conference, but at the beginning of last year, this was not so clear. And in this case, there was a minor attempt to complain about this, but the panel clearly and very well said that the right to be heard doesn't comprise a right to a hearing. In other words, the right to be heard can be perfectly respected even if there is no hearing. And secondly, the panel is entrusted with managing the procedures in a speedy way and resolving them fast. And therefore, the only way of doing this was actually by holding a video conference hearing, which actually went very well. The second procedural issue came from the fact that Huesca didn't manage to file its answer on time. So the answer of Huesca was inadmissible. What were the consequences thereof? Well, the club, the Spanish club, could attend the hearing. It could make post-hearing briefs with a limited scope, but there were many other aspects of procedural aspects that the Spanish club could not accomplish due to its failure to file an answer on time. When the panel went on to the merits of the case, the first issue was to analyze whether Amiens, that had been called as a party by both appellants, had standing to be sued. And the answer was no, it did not. Why? Well, because Amiens didn't have to pay any sort of compensation. It had not been sanctioned by the DRC. And on top of that, none of the appellants were asking anything from Amiens. And therefore, it did not have a disputed right at stake. And for this reason, Amiens was considered to not have standing to be sued. Then the transfer agreement was analyzed, whether it was valid or invalid. And the panel considered that it was valid. Why? Because Östersund had agreed already with Huesca on the essential terms that are required for an agreement to be concluded. And this is how the agreement was concluded. Huesca sends an email saying, our offer for Godos is 3 million euros and a 20% sell-on fee. And this is a quote, and this is how it went, literally. Östersund's replies, the offer is okay, please draft a transfer agreement. So with this exchange of emails, the panel considered and confirmed that according to Swiss law, this is a valid transfer agreement. And because Östersund had never made any sort of reservation when it came to the acceptance of the offer, then it could not argue that there were some conditions that had not been met. Because the good practice would have required the Swedish club to actually look in or express that there were that it had not been convinced about the fact that there was an employment contract or a transfer agreement, sorry, in this case, concluded in its opinion. This was not the case, and therefore the transfer agreement was valid. The fact that Huesca later on sent a draft agreement to Östersund didn't change anything for 2 reasons. The first one is that that draft agreement was never signed and Östersund never returned it back. And in any case, that agreement only added secondary terms. It did not add or change the essential terms that had been previously agreed on. So therefore, this draft agreement could not supersede the previous agreement that had been completed by email. Once the transfer agreement was analyzed, it was the turn for the employment contract. Let's remember that the whole case arises because the player was the one that unilaterally terminated the employment contract. So when analyzing the employment contract, the panel confirmed that it was valid because it was not preconditioned to either the conclusion of a transfer agreement or to the termination of the previously existing employment contract between the player and Östersund. Therefore, in the absence of any condition, the employment contract in itself was considered valid. Then the appellants were also arguing that, well, there was a disciplinary violation, in their opinion, committed by Huesca of Article 18, Paragraph 3 of the RSTP. But the panel, once again, as many other panels have done in the past, confirmed that a disciplinary violation is irrelevant when we are determining the validity of an employment contract, or well, of a contract in general. And then there was the fact of the language of the contract, because the player argued that, well, the employment contract that Huesca gave me, or the document, to put it in other words, that Huesca gave me, was in Spanish. And I don't understand Spanish, so then this contract should be deemed invalid. Well, the panel confirmed that if a player signs a document, he does so under his own responsibility. And therefore, if he signs it in a language that he doesn't understand, he cannot afterwards claim that the document is not invalid, is not valid. In other words, if the player would have required a document in English, for example, that he would have understood, he should have requested this before signing the contract. So therefore, the player's employment contract was confirmed to be valid, as the DRC concluded. Once we know that there's a valid employment contract, the analysis went on to whether there was a just cause to terminate the contract. And the panel, like the DRC, confirmed that the player didn't have just cause. Well, the player argued that he did, or he should have been deemed to have just cause, because Huesca had falsely misrepresented the document that he had been given. He said that he didn't know he was signing an employment contract, and he argued that he had been deceived by Huesca. But once the evidence on file was analyzed by the panel, and once the panel could listen to the questions posed by the panel itself, but also in cross-examination by the different respondents, it was clear to the panel that the player had or knew that he had signed an employment contract. Why? Because the player recognized this during the hearing, and because he even recognized having negotiated the employment conditions that Huesca had offered initially. And therefore, it could not be accepted in any way whatsoever that the player had actually been coerced or mistaken in any way whatsoever. Once it was determined that indeed there was no just cause to terminate the contract, then it was the time to analyze what are those the consequences of a breach, a unilateral breach of contract without just cause. Well, the first one, as you all know, is whether there is an amount to be paid for compensation of such a breach. In this case, the DRC, when analyzing the case, looked at the employment contract and saw that there was a liquidated damages clause that established that if the player terminated the contract prematurely, he would have to pay 40 million euros to Huesca. Well, the DRC decided to disregard that clause and analyzed the compensation on the basis of the objective criteria of Article 17, Paragraph 1. But the panel concluded that this was a wrong approach from the DRC side because according to the Swiss Code of Obligations, if there is a liquidated damages clause, the deciding body doesn't have to disregard it, but it has to take it into account and, if considered necessary, lower the amount to find a proportionate compensation. In any case, in this procedure, since Huesca had not requested or had not appealed the decision and had not requested that the liquidated damages clause be taken into consideration, then the panel went on to analyze the different criteria of Article 17.1, recalling that it is not an exhaustive list, and recalling that the panel has a wide margin of discretion when identifying the different objective criteria that can be taken into consideration in each case. In doing this, the panel also considered that the DRC had not taken into consideration that Huesca actually saved money or didn't have to spend a considerable amount of money. In particular, 3 million euros were not paid to Östersunds for the transfer fee that had been agreed, and none of the salaries, which amounted to 1.8 million euros, had been paid to the player. And because Huesca was unable to demonstrate that it had suffered any sort of damages, for example, for replacement cost and so on, then the panel was of the opinion that no compensation was payable to Huesca. And therefore, because no compensation was payable to Huesca, there was no need to analyze whether the DRC had correctly identified Östersunds as the jointly and severally liable club. Now that we know that there was no need to pay compensation, we had to go to the second possible consequence of breaching a contract, which is the sporting sanctions. In this case, the violation of the contract took place during the protected period, and therefore the DRC imposed sporting sanctions on the club and the player. If we focus first on the sanctions that were imposed on the player, we can see that the provision of the RSTP establishes that these sanctions have to be imposed on any club found to be inducing a breach of contract, and there is a presumption that this club signing a professional has induced the player to actually terminate the previous contract. With respect to this point, the panel stated that sporting sanctions had correctly been imposed on Östersunds because even if the Swedish club wasn't the club signing a professional who terminated the contract, because remember, the player was already under contract with Östersunds. But even if the Swedish club wasn't literally the club signing the professional, it was the club that benefited from the breach of contract. And therefore, if one understands the purpose behind the provision, which is basically to ensure and reinforce contractual stability, then a more general and teleological interpretation has to be carried out in this case, and therefore Östersunds, who pressured the player in order to be or receive 1 more million euros than what had already been agreed with Huesca, had to be sanctioned for its conduct. Finally, with respect to the player, he never challenged the sporting sanction. He actually served it from the very beginning, and as a result, there was no need to analyze what was the situation or if the DRC had correctly or incorrectly imposed a sanction on the player. So with this, I reached the end of my presentation, and I think now it will be the turn for any questions. Thank you.
Thank you very much, Jaime, for this very clear and detailed explanation of these very interesting cases. I can tell you that for now, we have not received any questions apart from several people contacting us, telling us how detailed your presentation was and how nice and detailed explained you have done it in your presentation. So what I can tell you is from our side, thank you very much. It has been very detailed. And I'm sure that if there will be any questions in future regarding those cases that you presented, we will be able to forward them to Jaime, and he will for sure be able to answer if need be. This brings me to the next part of today, which will be our next two speakers. So we move on to Carlos Schneider, who is the FIFA head of ethics and disciplinary department. And he will provide us with an overview of the CAS proceedings against the FIFA decisions in his métier, meaning in the disciplinary and ethics proceedings, followed then by a presentation also with some interesting cases by Mario Galavotti, the FIFA Director of Independent Committees, and you will have the opportunity to make your questions to both of them together. So please, while Carlos is presenting, you can already send in questions, and then the same goes for Mario, and both of them will be pleased to answer all your questions together. So this is enough from my side. Carlos, the floor is all yours.
Thank you. So, hello everyone. I hope you are enjoying as much as I am doing today. So, first of all, I would like to thank the organizers here, Maya and obviously Emilio Garcia, for organizing this exceptional event. It is my understanding that this event should aim to a double purpose: to briefly show the situation of our different legal departments in terms of facts and figures, and second, to bring forward interesting topics, sometimes controversial ones, and open the debate, or at least demonstrate that FIFA is not distant from the ongoing issues and legal problems. And this is exactly the purpose of our shared presentation. You will find here how Mario, our Director of Independent Committees, and myself have decided to structure today's presentation. It is my turn this time to show some facts and figures from 2020, mainly explaining how COVID-19 has impacted or not in our daily work. Further, I will embark in what I think is an ambitious challenge, that is the debate about third-party influence. This, I think, is challenging because FISFA's consistent approach has experienced some sidekicks lately from CAS, and we have to assume that maybe, and only maybe, our initial understanding of the notion of third-party influence, or more specifically, influence, needs a revision and a thorough internal and external debate. Following this topic, Mario will present another sensitive one on the fight undergone by FIFA to protect physical integrity and mainly against sexual abuse in football. But first things first, what happened in 2020? So let's start with the disciplinary department. Surprisingly, this year has been very active in terms of numbers. Despite COVID-19, we experienced no significant changes, at least during the three first quarters of the year. The number of cases have indeed increased during last year, where the average of cases opened went up almost 52%, from an average of 76 claims or cases opened per month. We moved up to 116. The graphics in front of you show how this is distributed. While in 2019 we had 914 cases, 2020 shows an increase of cases of up to 1,393. And already in the first 2 months of this year, we opened 223 cases. Again, as indicated in previous events of this kind, our main concern are what we call PSD cases. These are the enforcing of FIFA decision, now also with the new Article 15 CAS decisions. Also interesting in this last graphic on the right, below, shows a tendency that I will touch again in my next slides. In terms of decisions from our bodies, again, we bring this year very good news. The disciplinary committee has been able, once again, to increase significantly, I would even say, the number of decisions connected to Article 15. Again, failure to respect decisions. We witness as well a decrease of TMS cases from 168 to 81. And this finds its reason on the fact that 2019 was already an extremely productive year. In terms of numbers and considering the existent backlog back then, the disciplinary committee was able in 1 year to decide almost on 6 times more cases than in the previous 7 years. As a result of this significant effort done by our deciding bodies, a decrease of decided cases derives more from a normal dynamic of the decision-making process than on any possible other reason. Other types of cases have remained similar in terms of numbers, like, for instance, the extensions of decisions to have worldwide effect or other matters. Those that I like to say are the traditional disciplinary matters. This includes fan misbehaviors, red cards, etc. One of the big, if not the biggest success of 2020 has been the evolution of active cases. The result of it derives from our initiative started at the end of 2018 when we designed the strategy to confront the existing backlog. Back then, a case or a claim entering in the system had an average of over 3 months before it started even to be considered or disciplinary proceedings to be opened. It was not rare at that time that a decision was imposed even 1 year after the claim arrived, let alone the time to notify the grounds dramatically extended that period. First task was therefore to get rid of the backlog, which was successfully done in 2019. Second task was to establish a smooth procedure by means of which a claim or a case should not remain in the system for a long time. And here, mission accomplished. The graphic on your right shows the current pattern of active cases. Today, the average time to decide on a case is far less than 2 months, and grounds should be ready to be notified, with obvious exemptions, in around 21 days. We have been able to reduce to the minimum the number of active cases, which eases the workload of the colleagues, as well as the one of the members, and should, in principle, increase the quality of the decision-making process. The same goes for the appeal committee decisions, which have not experienced major changes in 2020, when numbers have remained almost the same in terms of admissible appeals, appeals upheld, or partially upheld decisions confirmed. It's a win-win situation, and all this, I must say, is the result of the combined forces of our committed members and our outstanding colleagues from the department, who have demonstrated a perfect synchronized teamwork. And here are the results, on which I'm only the messenger. So thanks to all for allowing me to look pretty today. But I'm already anticipating what will happen in 2021. The tendency here is go down rather than high. I think in this period of pandemic, we slowly have become experts in reading statistics and graphics. At least this is my own feeling. If we take a look at the graphic in this slide, we see that the peaks are lower the more we enter from one trimester to the other. The tendency is evidently going lower, and this we already have started to anticipate by the end of last year. All this should be in context that while topics on TMS extensions and what I call traditional disciplinary matters remain steady, what we call PSD cases, those of Article 15, will and are, under my view, experiencing a significant reduction. The reasons, therefore, we could find in several causes. The use of proposals for solidarity and training compensation combined with a high rate of acceptance. The application of Article 24 bis of the RSDP, imposing directly the relevant disciplinary measures and avoiding the opening of disciplinary proceedings. Also, would it be accurate to say that party seems more respectful, or the process is more efficient and strict, that is, less calling for bad payers? We are talking here of a change of average of almost a year to a maximum of 2 months, and I wish that this would be the main reason. As for the future events, the implementation of the clearinghouse, where all solidarity payments and training compensation cases will be conducted almost automatically through this platform, will result in almost no cases of this kind anymore for the disciplinary department. As a consequence, we anticipate in 2021 less decisions in matters related to Article 15 of the disciplinary code. And being that the core business of the disciplinary department, it will reduce significantly our daily work. So much for the disciplinary department. And now let's move to the ethics department, where we find also some good news to be proud of. Here again, we experience the same or similar evolution, maybe because the strategy was almost identical for the ethics department as well. That is, let's work on the existing backlog and move then to a smooth and dynamic process. Obviously, ethics proceedings are different from those of the disciplinary department, as investigation and adjudication respond to different patterns and have and are under different requirements. But let's start with the investigatory chamber and put things in context. Two main conclusions are to be drawn from these graphics. First, the number of preliminary investigations, those entering in the system every year and where a prima facie analysis is required on competence and also on the potential existence of an ethics violations, has steadily increased, regardless from the fact of the pandemic. Second, even though those investigations have increased, the ethics department has been able to reduce the backlog and keep a steady number of investigations moving to the next stage. So let's move now as how COVID has impacted our investigations. I have to admit that I'm a very positive person. An example of it is that I trust that as of April, we will start breathing again with this pandemic situation. The same goes on the effects this pandemic had on our different proceedings. On a downside, COVID has provided the following negative effects on our investigations. On-site investigations could not be undertaken. Personal interviews were not possible. Access to the association's premises was limited. Contacts with police or other public authorities was also very limited. A delay occurred in the investigation proceedings. However, new year, new life, and the ease of restrictions in 2021 had a significant impact on the dynamic of the formal investigations. As you can see in the graphic, already at the beginning of this year, 5 cases moved to formal investigations, while in 2020, we could only move 6 cases to formal, still being the amount of ongoing formal investigations of 11, almost the same as in 2019. You know, I keep positive. But what this situation has provided to us is to explore the possibilities of our code, that our code is offering to us. A very good example of it was the Haitian case involving the former president, Mr. Barth. Due to the restriction faced because of COVID, the investigatory chamber decided to appoint an ad hoc panel which exercised the investigative duties. This experience was very positive and provided, amongst others, the opening of 5 formal investigations, resulted in a decision against Mr. Barth of a life ban, triggered at some point the implementation of a normalization committee, and opened new lines of investigation. All in all, this option has demonstrated to be effective and highly dynamic. Let's see if in the future the investigatory chamber will continue to make use of this prerogative. We had the same positive feedback with regard to the adjudicatory chamber. In this regard, the impact of COVID situation was very intense. According to the former FIFA Code of Ethics, in case a hearing was requested, there was no possibility to hold a video conference, impeding a smooth decision-making process and keeping matters on hold until either the COVID situation is over or no hearing was requested. Again, this provided the opportunity to evolve and adapt. As a result, FIFA amended the code on 25th of June 2020. This code came into force on the 13th July 2020. On an exceptional basis, further events like a pandemic, hearings should be permitted to be organized by video conference. This allowed the parties who request a hearing to enjoy it and act before the adjudicatory chamber, while the respected ethics proceedings would be able to continue. The graphic on your right is the perfect example of how this reaction by FIFA had a positive impact on the decision-making process. A little over-exaggerated maybe with the rocket, but nevertheless exposing the significant impact it had for the process. Obviously, the dynamic is different as in the previous years, where again, the purpose was to attack the existing backlog. I recall last year, the adjudicatory chamber decided on 40 cases, but the pace is back to normal. And we can assume that 2021 will be again normal. We expect to have around 20 to 25 decisions, which is already doubling the average number of decisions taken in 2018. So, time for the challenge. First of all, I would like to thank my colleagues from a new created hub for the legal division called Knowledge Management. They have worked out this topic for me and have assisted me in this process. So let's start. So first thing is obviously the creation of the provision or the concept. Let's say the concept. Third-party influence was created as a result of the increasing involvement of new actors in football, when FIFA decided in January 2008 to create and include Article 18 bis in the RSTP. In particular, FIFA noted that professional football attracted the attention of entrepreneurs who started to see football as a lucrative business opportunity. In this respect, FIFA witnessed that a number of these entrepreneurs, third parties, were able to influence transfers as they controlled, in whole or in part, a player's right. Therefore, the original objective of Article 18 bis was to prohibit clubs from granting third parties a right to say in transfer agreements or professional contracts, thus depriving them of the opportunity to influence the autonomy and internal operation of the club or the performance of the teams concerned. Following the creation of the transfer matching system, TMS, in 2009, which gave FIFA better access to contracts concluded by clubs and players, FIFA understood that the prohibited influence did not only come from non-football parties, third parties, but also from other clubs. Accordingly, the general ban on TPO third-party ownership was introduced into the RSTP in what its current version. This amendment enabled the FIFA judicial bodies to sanction not only the influenced club, but also to prosecute the influencing club, something that was not possible under the previous version. Since the introduction of Article 18 bis, one of the major criticisms is the lack of a clear definition of influence and the concept notion underlying this term. In this respect, FIFA seemed reluctant to conceptualize the notion of influence directly in the regulations, but considered that the term had to be determined in the case law of its judicial bodies, and CAS by means of concrete cases. However, although recent years has seen an influx of decisions by the disciplinary committee, neither the adjudicating bodies of FIFA nor CAS have been able to provide clubs with a clear definition, or at least conceptualize the notion of influence, which has led some football stakeholders to express their dissatisfaction. In September 2020, FIFA published the FIFA Manual on TPI and TPO, in which decisions on Article 18 bis were analyzed and commented upon. In this respect, it appeared that due to the lack of a clear understanding of the concept of influence, contradictory decisions have been issued. In light of that, it now seems indispensable to define the notion of influence, but above all, to qualify this notion. According to the Lexical Dictionary, influence can be defined as the capacity to have an effect on the character, development, or behavior of someone or something, or the effect itself. In different legal fields, the concept of influence has been further specified and given different thresholds as to when an agreement, action, behavior, etc. can be considered an influence. In fact, in the field of football, 3 different concepts can be already deciphered in the regulations of the Champions League, UEFA, in the UEFA Club Licensing and Financial Fair Play, and in the Premier League Handbook, respectively. In line with this, 3 different notions of influence can be identified: decisive influence, material influence, and significant influence. So, which one should apply? Should we apply any of them at all? So let's try to analyze each of them. Let's start with the decisive influence. The legal field in which this concept of decisive influence most predominantly appears is the EU merger control. I'm not an expert in merger control at all, so I hope that there is no question on that, but it's the definition which I think it's interesting in this case. Specifically, according to the EC merger regulation, control should be constituted by rights, contracts, or any other means which, either separately or in combination, and having regard to the consideration of fact or law involved, confer the possibility of exercising decisive influence on an undertaking. This gives us a broad idea of the concept of decisive control. Having said this, it cannot be denied that the threshold for decisive influence is a high one. In a sense, someone would be capable of influencing overall business plans of the undertaking, influencing overall budgetary decisions of the undertaking, having veto rights vis-a-vis any decision that the influence undertaking might be willing to take. Translated to football, a third party capable of exercising a decisive influence over football can influence the entire decision-making process of the club. Its influence would not be limited to, for example, whether or not a player is to be transferred from the influenced club to another club. This high threshold was further exemplified by the UEFA Judicatory Chamber of the club financial control bodies, who argued that in the benchmark for establishing decisive influence is a high one, requiring the ability to direct the decision-making of both clubs by any means. So let's move to the second one. The concept of material influence is enshrined in clause 1.7 of the Premier League Handbook. Coincidence or not, with regard to merger control at national level, the UK applies the material influence test in order to determine control. In a nutshell, material influence includes the ability to materially influence the economic behavior of the target business, included but not limited to decisions relating to pricing, purchasing, distribution, etc. Importantly, a party with the ability to materially influence an undertaking still has a great degree of control over that undertaking. Although the threshold is lower than the decisive influence, a third party with the capability materially to influence a football club can influence that club's policies in a broad sense. Here are terms that we will use afterwards when analyzing the case jurisprudence. Here too, its influence would not be limited to, for example, whether or not a player is to be transferred for the influence club to another club. In general, this in football. So let's move to the third notion. Again, back to UEFA. According to UEFA, significant influence is the ability to influence but not control financial and operating policy decision-making. Significant influence may be gained by shared ownership, statute, or agreement. From the outset, the capability to significantly influence an undertaking appears to have the lowest threshold. given that it is accepted to be the power to participate in the operating and financial policy. In general terms, indicators could be material transactions with the investee, policy-making participation, technical information exchanges. Translated to football, the quintessential difference is that the significant influence does not require the third party the capability of exercising control over the football club. In other words, a third party can acquire the ability to significantly influence a club in employment and transfer matters, its independence, its policies, or the performance of its team without having control over the club. So the question remains, what is the correct approach on the notion of influence? Decisive, material, significant? And here I must say that we find some contradiction also in the most recent casus jurisprudence. In some cases, even complex, and we could say difficult theories in terms of practical implementation. Let's start with the CAS award on Sevilla. And CAS here puts emphasis on three different aspects. The influence should have effect on or predominate over the independence. Should exercise significant influence. But at the same time, it should have the real ability to have effect on, determine, or impact the behavior or conduct of the club. And is this the definition of significant influence, or is it more material influence? This CAS has not really solved entirely. Further, Chelsea, which I already anticipated, presents some confusing statements. Briefly, influence is the ability to influence in employment and transfer-related matters when it affects its independence, its policies, or the performance of its teams. There must be a network of similar agreements for various players, and it should be considered the relative standing, the prominence, and market power of the involved clubs. While we could agree on the fact that the special circumstances of the clubs or parties may play an important role, a relevant role, as to asserting the existence of influence, which in this case remains open, the same is difficult to accept with regard to the network of similar agreements. Here, the thought is simple. The existence of this so-called network would expand the analysis of the clauses that are first confidential and second have no relation to the contract. This approach, under my view, is unpractical and difficult to implement. So we have another try with a very recent CAS award on a clause deemed by FIFA infringing Article 18 bis, which has lately also been discussed media-wise, but on which the arbitral tribunal found no such violation. This is the case of Real Madrid and a young player transferred from Manchester City. In a nutshell, CAS' approach is summarized in these main aspects. First, influence, direct or indirect, should be determined by the position through which it may influence, and B, by the affection on the independence of the clubs. Second, three conditions. There will be an undue influence if the following conditions apply. The existence of influence, that such influence produces a limitation in the independence of the club. And third, that this limitation is such that it threatens the integrity of the competition. As a consequence, not all contracts agreements creating reciprocal rights and obligations between clubs, for example, to transfer players, will amount to a breach of Article 18 bis. Such a breach will only occur where the integrity of the sport is damaged as a result of one party using its influence to affect the independence of the other party. This is important because CAS is here combining two different notions, integrity and affection of independence of the parties. So how is this translated in this particular case? The panel, bearing in mind the fact that it's one of the most prominent clubs of the world, deemed that a clause like the one in this case did not have that impact or derived a sort of subordination from the other club towards Real Madrid. Well, from Real Madrid towards the other club. So it accepted that there was an influence. It accepted there was a limitation of the independence, but it didn't accept that this affection was of a very high intensity. So now, finally, some would say, coming to the end, before I pass the floor to Mario, please find here a short list of the key findings of this complex issue. The ratio legis. FIFA focuses and certainly puts emphasis on the autonomy of the clubs with regard to the transfer agreements, obviously blocking any potential interference. CAS seems to accept that, but is not, under my view, reaching the target as how to fit this goal within the FIFA general goals and objectives, and varies its legal reasoning from autonomy of undertakings to network of policies to safeguard integrity. In a context where there is still no definition, it appears that FIFA has steadily defended a concept closer to the one of significant influence, while CAS appears to move slowly to a material influence notion. Many questions unanswered remain with the recent CAS award. What kind of influence is prohibited? What is the decisive element? Integrity vis-a-vis the contractual freedom of the parties? And what about fair play towards other clubs affected by these clauses? Finally, will the next case or cases before CAS help us out here? In any case, this deserves an internal discussion, but also a specific one with the stakeholders, as this is our intention and talks have already started. So thanks so much again, and I will give the floor to Mario. Thank you.
Thank you very much, Carlos, for this very detailed presentation. And we will continue now with the second part of this part of our FLAR today. And the next speaker is Mario Galavotti, and he's joining us from Italy, and he will take over for the second part of the disciplinary and ethics proceedings in 2020, the main figures and cases. So Mario, over to you, and I hope all is fine in Italy.
It's fine. Thank you, Maya. Can you hear me, first of all? Good.
Loud and clear.
Very good. Good evening. So good evening, good morning, wherever you are, as usual. And as Emilio said, a year has passed, but we are still here looking at each other through a screen. And more important, we are starting now to be accustomed to such screen. I don't know what if and what we can plan for the next edition, but I want to share Emilio's optimism and think that soon we will be able to finally head to Buenos Aires or to any other loving football, beautiful cities around the globe. In the meantime, let's stay safe. Today, after Carlos' overall presentation of what we are doing at ethics and the disciplinary committees, I want to talk to you more specifically about the recent cases of sexual abuse in football, of course. And especially I want to talk to you about the, let's see if the clicking is working, not yet. Not yet, well, yes, okay, good. Okay, thanks. Especially the case related to the Federation of Haiti, as Carlos mentioned, which prompted FIFA to consider some new initiatives, of which I will mention shortly. Let me see if I can No, it doesn't work. Can you help me now? Can you give me the code again?
Sure, Mario. So whenever you want, you just tell us next slide, and then we'll take over from here.
Next. The first case of abuse that the new FIFA Code of Ethics dealt with is the one of which Miguel Liedard already referred, concerning the president of the Afghanistan Federation. This story, as outlined by Miguel, emerged thanks to the courage of the young athletes who rebelled against the very serious situation of physical and psychological subjection in which they found themselves. They faced big risks, and with the help of FIFPro and of FIFA, they managed to escape the very dangerous situation. They certainly deserve our deep respect and our gratitude. The other case that was also largely reported is the one that emerged in 2020 concerning the Federation of Haiti and its president, as we said before. We know that in both cases, the accused were sanctioned with the maximum sanction provided by the Code of Ethics, life ban and a fine of 1 million Swiss francs. And as we have seen, the decision involving Mr. Karim Karamuddin was confirmed also by CAS, while the decision on the merit sanctioning Yves Jean Bart is under appeal before CAS. However, CAS had confirmed the decision taken by the Ethics Committee to impose on Jean Bart a temporary sanction during the investigation. Next, please. The case of Afghanistan, however, is very relevant also because it suggested an amendment to the FIFA Code of Ethics. In fact, if a sexual abuse connected to abuse of position, as was the case of the president of the Afghanistan Federation, allowed the application of severe penalties like life ban, for example, the 2018 Code of Ethics, FIFA Code of Ethics, did not provide for sufficiently severe sanctions in case of sexual harassment or abuse committed without a specific abuse of a position. Next. So therefore, upon the suggestion of the Ethics Committee, you can go next. Upon the suggestion of the Ethics Committee, in 2019, the wording of the Article 23 of the FIFA Code of Ethics was adopted, and with a clear distinction between harassment, abuse, and also sexual exploitation by providing different sanctions with a minimum of 10 years in case of serious cases, 10 years of suspension, of course. And similarly, the time limit of prosecution was raised to the maximum foreseen by the code and aligned to the 10 years foreseen for the other major infringements. So now we have 10 years minimum sanction, 10 years of suspension minimum sanctions for very serious cases, and 10 years time limit for prosecution for in case of serious sexual abuse for exploitations. Next. So now with the amendments, as I said, greater sanctions can be imposed in case of sexual abuse, harassment, also on officials that are not infringing the code, abusing of their position. And this is the case, for example, of proceedings that are pending against other officials of Haiti Federation. As you know, you can because I just you know and the FIFA recognizes the autonomy of confederations and associations. However, we believe that matters related to Article 23, so sexual abuse, sexual exploitations, should be reserved exclusively to the competence of FIFA. And there are ongoing discussions to extend the FIFA Ethics Committee exclusive competence on this Article 23. Indeed, I must say that in both cases, Afghanistan and Haiti, the FIFA Ethics Committee took action upon request of the respective confederations. Next. Just let me go back quickly to the impact that COVID had on our proceedings. Next. Next. Yeah. As Carlos said, as soon as it became clear that the travel restrictions imposed by the pandemic would last longer than we could have expected, the Council introduced the small amendment of which Carlos mentioned before, allowing the hearing to be held online. This was not the case before, and the change allowed the adjudicatory chamber to hold their hearings regularly using the technology. And I must say that I want to add to what Carlos already said, that such technology so far worked very well. And the case, the proceeding against the president of the Haiti Federation was the first test. We had a day-long hearing held regularly, also with several witnesses and the help of interpreters. So at the end, the technology resulted to be a very good resource for the functioning of the Ethics Committee, and I'm sure that certainly will be further used in the future. Next. But the pandemic, as Carlos mentioned it, had an impact also in carrying out the investigation on the Haiti case. And as we said, COVID forced the investigatory chamber to adopt a totally new method of investigation, with the appointment of a local panel with different professionalities, different skills, which I will return to it because this represents a new organizational model that can also be adopted in the future, and that FIFA is willing to implement also in other cases. Can we, next? In this type of proceedings, as presented by Miguel, one of the most relevant element is the anonymity of the identity of victims and witnesses. Next. Yeah, that indeed the reasons of security and respect for privacy require, as pointed out by Miguel, the utmost caution to protect victims in all the proceedings for sexual abuses. Next. In addition to an efficient whistleblower reporting system, the FIFA Code of Ethics provides that some testimonies can be made anonymous under certain mandatory conditions. And as reported before by Miguel, there are several requirements according to the FIFA Code of Ethics to motivate the request to remain anonymous. And the fact that CAS deemed it legitimate in particular circumstances to ensure the anonymity of victims or witnesses, this is extremely important for the future cases, and will be an important precedent for the victims to provide them a greater confidence in the ability of their sport institution to protect them and also to sanction the perpetrators of such relevant and important infringements. Next. 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 No, as I approach to the conclusion, I would like to mention another interesting aspect relating to the application of interim sanction. As you know, during an investigation conducted by the investigatory chamber, a provisional sanction for a period of 90 days can be adopted directly by the chief investigator, while an extension for a second period of 90 days can be requested by the chief investigator, but can be adopted only upon a decision of the chairman of the adjudicatory chamber. So it was in the Haiti case, also due to the complexity of the investigation conducted in a quite hostile environment and during the peak of the pandemic, which imposed severe traveling restrictions. Mr. Ambart appealed on the decision on provisional measures, assuming that in the absence of an identified victim, there can be no sexual abuse, and therefore there is no violation of provision of the FIFA Code of Ethics. CAS, however, confirmed the decision of professional sanctions adopted by the FIFA Ethics Committee and made some interesting statements in this regard. In light of the evidence, CAS said that it appeared very probable that a breach of the FIFA Code of Ethics had been committed. The decision on the merits could not be taken early enough, as the investigations are long and complex, as several victims, and this is a very relevant statement by CAS, were concerned, and COVID-19 negatively affected the timing of the investigation. So we had two acknowledgements from CAS, the concern of the victims threatened of retaliations and the COVID-19 impact on the timing of the investigation. So only exceptional circumstances can justify the extension of provisional suspension, provisional sanctions, which CAS found existing present in this case. Next. 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 As I said, why the Haiti case was so relevant in the policy of tackling sexual abuse. Because the Haiti case led the Ethics Committee to some reflections. First of all, as I said, the restrictions linked to the pandemic made it necessary to appoint a team of investigators on the spot with different skills, as I said, who could collect the necessary evidence to instruct a disciplinary procedure, and also to make the victims more available to disclose their testimonies. Furthermore, the investigation highlighted not only the fear on the part of the victims, this is the most relevant part of this case, not only the fear on the part of the victims and witnesses of being subjected to retaliation, but also and above all, a widespread mistrust on the part of the victims in their sport institutions, their federation, their coaches, their club, and even in the same FIFA. So last September, FIFA and the United Nations Office on Drugs and Crime signed an MOU to closely cooperate to ensure full integrity in sport. And FIFA launched a project of a global multi-stakeholder commitment through the creation of an independent international entity for all sports, with the aim to establish a global, I would say, pool of experts, a network of volunteers, universities, professionals, able to be mobilized quickly to provide support to victims and witnesses on spot, like the ethics committee did for Haiti. Whenever a case of abuse in sport is reported, and providing sport justice bodies with evidences suitable for the respective disciplinary proceedings. So this entity, this agency worldwide will support victims, will investigate in an independent way, will report, will provide a final report to the competent sport federation for them to take action on a disciplinary basis. The new entity will also be able to establish screening processes to ensure that perpetrators cannot move from one sport to another or between different sports, nor escape justice, or to move from one region to another. Since October 2020, after the signing of this MOU with the United Nations Office of Drug and Crimes, extensive stakeholders engagement and research has been undertaken with the aim of defining the mission. The delivery of a report for this very large consultation process will be ready by the end of this month, should be ready by the end of this month, followed by an establishment of a working group to further define and establish the new entity, the regulations, the functioning. The president of FIFA has already discussed the project with several governments and also with several sport and political international institutions, and will also address an upcoming G20 conference. As we know, sport legitimately claims autonomy, and so the right of self-governance and exemption from oversight by governments and judicial authorities. However, I believe that to be able to maintain the autonomy, sport must remain within the law and conduct a responsible autonomy. The autonomy of sport will never be legitimate if connected with child abuse. This is why FIFA and football decided to seriously tackle any kind of abuse and help all the other sports to do the same. Maya, I will stop here. I'm sorry for the technology. The delay was probably large, but I hope that we will fix it for the next time. Back to you, Maya.
Thank you, Mario. No worries at all. On the contrary, it makes it a little bit more human, and more natural than in this very empty area where we are, with everyone with a mask and nobody's laughing, even if I make jokes, and everything is working perfectly. So actually, I like that part. It's a little bit more normal. I actually have two questions that I would like to ask to both of you, and then it's up to you and Carlos to decide who would like to answer, or if you want to answer together. The first one is a more general one, and it's in connection with the application of Article 15 of the FIFA disciplinary code, which is limited to players, coaches, and clubs. And the question is, why don't they implement CAS awards on agents and intermediaries, the code, especially considering Article 3 of the code, the scope of personal application, which mentions that intermediaries are subject to the application of the code. So the question is for both of you.
Yeah, we discussed it. Carlos, back to you. We discussed it a lot, this matter.
So I can answer this one. Well, it's a very complex question, and it will have a very complex answer. First, I will go with the statement that it's incorrect that it does not apply, or that it does only apply to players, association coaches, and players. If you go to Article 15, Paragraph 1, this list is just as a way of example. It's an open list, and therefore the second part of this question is completely accurate. Article 3 contemplates the intermediaries, and by that, Article 15 should in principle also apply to intermediaries. And on top of that, the way it applies to intermediaries this is why the second part of the question was so good, is that it mainly only applies through the CAS decisions, because it seems, at least for the time being, a little bit difficult that we can apply that we can enforce, so to say, other decisions on intermediaries that are not coming from CAS. But again, the question is complex, and it deserves a very complex answer. It's not that simple that we have a CAS award on intermediaries and that we are automatically implementing that CAS award. First, we changed the Article 15, so we only apply CAS awards that started after the enforcement of this code. So that will be a first limitation. Second, what is intermediary? So we all know a little bit from the football world what an intermediary is. An agent, no, we know the big agents in football, but are they qualified as intermediaries? I would say the big one, yes, but the generality of intermediaries, some do and some do not. So we need first to solve the issue of the fact if that intermediary or that so self-called intermediary is allowed to apply or to request or to claim the enforcement of Article 15. And that comes the third particularity here, is that intermediaries or the regulations of intermediaries has been a little bit of a football game. Like first, the ball was on FIFA, then it passed the ball to the associations, and now again back to FIFA. Back to FIFA means that in due course, as we normally say in FIFA, we will be back regulating the intermediaries and also decide on disputes involving intermediaries. So when we started back then with intermediaries, and then it moved to the associations, we have here an issue of competence. So we were competent for those. Then it remained on the association, and then we in the meantime we apply the Article 15 and some circulars, and the temporal application of our regulations to intermediaries is affected by the specific context of the intermediaries. So it doesn't follow automatically that the consideration of intermediary would give you the right to claim of Article 15. And I can say that, and it's not something that I prepared before this presentation. So it's because we have been, or we already started to receive some claims involving intermediaries, and by that the disciplinary committee has started to decide on cases on intermediaries, and those cases and those decisions will be published once they have been notified or communicated in our webpage. So I would say I will plea for some patience, and once these decisions will come out and also be discussed before CAS, because I already anticipate that not everyone will be happy with those decisions or those outcomes. We will defining a little bit more into depth the involvement of intermediaries and the application of Article 15.
Thank you very much, Carlos. And I don't know if Mario would like to add anything, but otherwise, we are very happy to have had both of you here. So Mario, if you would like to add anything.
Well, thank you. I think that the new regulation that the FIFA is going to release on agents will change again. As Carlos mentioned, will change again the situation.
Thank you very much. So this will be all from our side. So thank you both of you, Mario from connecting from Italy and Carlos from joining us from Spain, for being here with us during this event here in Zurich. And now we will, you came from Spain to join us today here in Zurich. And now I would like to go to the break, and we will be back at 18:00 with the last presentation of the day, Outside Football Law, Sports Law Matters in 2020, with our guest speaker, Sean Cottrell, who is not a FIFA speaker. So see you in 10 or 9 minutes. See you later. Thank you.
Sebastian, are you there? Sebastian, so I hope I got my headphones.
Welcome back to the last presentation of the first day, Day 1 Review 2020 of the third edition of the FIFA Football Law Annual Review. So we have had some very interesting presentations from inside FIFA members about the activity and the leading cases of the various decision-making bodies. Now it's time to give the floor to an outside person, to an outsider, someone who is able to speak to us about a review of 2020 on sports matter outside football. And it's my great pleasure to introduce to all of you our speaker, Sean Cottrell. Please send him in any questions that you would like him to have answered during the presentation. And if there is still time, we will have also a Q&A session once he is done. So I hope you are joining us, Sean, and I give over to you.
Well, thank you very much, Maya, for the kind introduction, and thank you to the team at FIFA for inviting me, and particularly Emilio Garcia. As many of you, and I'm sure actually many of you don't, but for anyone who has the unfortunate situation of following me on Twitter or LinkedIn, you will know that when FIFA announced the Football Law Review many years ago, I was a huge proponent of this initiative to try to explain some of the real basic issues that FIFA are dealing with on a day-to-day basis to improve the understanding of football law matters. And I'm delighted, well, I think I'm delighted. I'm not sure why Emilio's asked me to talk about non-football matters at a football law conference, but I hope many of you will stick around for this presentation. What I'm going to try to do over the course of 30 minutes is to talk about some of the legal issues that took place over the course of last year and have a look forward at what issues and developments have been taking place that may have an impact on the football industry, but not necessarily directly related to football. So if you do have any questions, I'll be glad to take them at the end. And it's a real pleasure to speak with you, whatever time of day it is, wherever you are in the world. So there's lots of things that have been going on. Obviously, you've been giving the topic to cover legal issues outside of football. There's no end of issues that we could talk about. However, for many of you that don't know me or Law in Sport is an organisation and global platform that is one of the leading sports law resources in the world. And what we try to do is provide legal analysis and commentary on the latest legal issues and developments from the world of sport. Now, we do that in a number of ways. We do produce content, and we've produced over 2,000 peer-reviewed articles. We host a number of events and conferences, webinars, mentoring schemes, and many other initiatives over the course of the year. We have 29,000 members worldwide. Now, I should say that whilst this is my opinion, and it is just my humble opinion on what I think have been some key issues and trends and cases that have taken place over the course of last year, to be honest with you, I'm more of a curator as opposed to an expert as such. What I have done is relied heavily on our outstanding advisory board and editorial board, who are made up of some of the leading lawyers from around the world. We have over 100 members worldwide from both in-house counsel, general counsel, sports organisation, private practice lawyers, solicitors, advocates, barristers, academics. And it's actually a lot of the work that they've done, and as well as our 100+ authors who wrote last year. So we've had over 800 authors who have written for Law in Sport. But what I did was take a sample of the 233 articles that we covered last year, using that as an indication of what are key developments, extracted some of the ones that were on football and part them to the side, and highlighted and tried to pick out some key trends. And I'll come on to that in a minute. And of course, I've taken it from the outstanding speakers that we've had talking at our events. And for reference, and many of you will know that I'm a big fan of making sure everything is referenced thoroughly. If you click on that link or go to that link, so go to Law in Sport /FLAR21, you'll be able to see all of the articles and links to videos that have been referenced during this presentation. Right, so we've heard about this already today. I'm going to briefly touch on, before I get into the other areas we're going to touch on, I'm going to give a short summary of the key developments that took place or were affected by COVID-19. And in summary, it caused an acceleration of changes in the sports market. It certainly highlighted the importance of lawyers and of contracts and having clarity of contracts and making sure, and I know there's going to be a big collective sigh worldwide or force majeure, we heard about it earlier, but the impact of these clauses is significant. And I think what we have definitely seen is the refocusing, let's say, and I know that a lot of my colleagues around the world were busy for a few months revising all the clauses that they'd written and drafted. Also, the importance of having the correct insurance cover in place. And whilst many organisations suffered for not necessarily having the right cover in place, there were some notable winners in that, which was Wimbledon, who reportedly received £140 million payout for having the right clauses in place. And also we saw the importance of having good governance structures in place, having statutes that allow you to make decisions remotely and making decisions effectively and quickly, whether it's an executive board or whether it's a council, and trying to get everyone together around the world when we can't all have the pleasure of meeting up. Also, as was highlighted earlier, the importance, or let's say the disparity between the employment status of athletes worldwide. And I refer to an outstanding report that I had the pleasure of putting together with my colleagues, Michele Colucci, Alexandro Coni, Rustam Stethna, and 60 other authors, and I can't reference them all now, being the report we did on football. And I know I'm not meant to be talking about football, but it's worth checking out that report because it highlights the important status of football, male and female, men and women around the world, and it shows you the disparity. And it also meant then which athletes, which players could, and which clubs could be entitled to be furloughed and to receive other state aid essentially during this difficult time. Also, governments have had to step in and help the sports sector worldwide, and it raises a number of very interesting questions around issues around state aid, and there's been certain provisions on that, and got some great content on that, but also at what cost. So what we're going to see as more money's been given out, obviously tax authorities were already being quite aggressive within football, but they're certainly been more aggressive, let's say, and thorough in other sports as well, which I'll touch on later. What's going to be the longer term implications of that for the sports sector? And I think, not having the right, if anyone doesn't have the right documentation in place, or they're doing anything that's very close to the mark, they may be in for a difficult time once we get over this pandemic. And of course, then we've touched on it already, and you've seen how successful FIFA have been at dealing with disputes over this period. There was an initial challenge and let's say refreshing or upskilling of people with technology. And again, a report that was led by Murray Rosen QC and many other of the world's leading sports arbitrators and lawyers put together this guide on the impact of COVID-19 on dispute resolution. Again, you can click to that now. And I should apologize for the interpreters. Emilio told me to talk slowly. And unfortunately, for many of you that know me, I get very excitable, particularly talking about sports law issues, as you would imagine, running a company that focuses on that. Now, I'm going to try to give you a brief explanation of the areas we decided to pick on. And so this is just a flavor of some of the topics that we went through and how we grouped them up. And so how we chose these areas that I'm going to focus on today is, of course, with no matter if you're doing amateur sport or professional sport, how sport is funded, the commercial revenue streams for it are incredibly important. So issues around sponsorship, Rule 40 with the Olympic Games, betting, data, image rights, agents fees, etc. Then we grouped up and looked at, right, okay, we've got where the money's coming from. Now, how is the sport governed? What are the structures? How can, as Carlos just alluded to as well, who's investing into sports organizations? And what are the controls in place there, and the related issues around that, and issues around diversity and human rights. Then we've got integrity matters, which we've heard a lot about, which I'm very grateful actually to hear so much about today. Not only anti-doping, match fixing, but of course, the really, really important issue that we've heard about today, which is safeguarding child protection, and obviously the Guardians program and initiatives we heard about in the last presentation. And next up, then we have athletes' rights and welfare. So the commercialization or the entitlement for athletes to commercial revenues. And then finally, and as well as the duty and this tension that we'll see between high performance sport and the welfare of individual athletes and players. And then finally, some notable cases in dispute resolution, both on the actual fact specifics of the case, but also on the structure and makeup of dispute resolution bodies, particularly arbitral bodies and the arbitrators. So first of all, again, just to recap, we're focusing on commercial issues. Why? because it's where sport around the world typically makes loads of its money if it's not government funded. So the pandemic caused everyone to revisit what they were doing, and particularly broadcasters. And there was already some pressure in certain parts of the world, particularly within Europe, about what sports events should be made freely available on free-to-air broadcast, and in places like India as well, I might add. That's going to be something which I think is going to be a continued discussion going forward as the financial pressures have hit sport, but the pandemic also highlighted the importance of sport and what it meant to participants. And obviously with the financial pressure that people are under, it was felt by many that maybe there shouldn't be a pay wall to access some of the content. But on that point, there's also been restructuring of how people are selling media rights, both in football and outside of football. Do they collectively sell clubs together? Do they sell as one league, or do they sell independently? What's the best model? What's it equitable? What gets the greater return on investment? And of course, as we've seen in France, there can be some difficulty if you look to change how you're going to sell your media rights. And finally, on this point, protecting and clamping down on piracy. And we've seen a number of high profile issues that I won't go into, but the beIN Sports case and the UFC have been publicly very aggressive on piracy. Again, this is going to be no doubt a notable battleground going forward, and one that's going to be very important to watch and monitor. Next up, we have the relationship between sport and betting. And undoubtedly, betting has contributed a huge sum of money to sport in various parts of the world. However, this relationship is changing, particularly in the more developed sports betting markets, where in Spain we've seen bans that are going to be introduced around sporting events. And in the UK, we're seeing self-imposed bans by the betting industry themselves to stop promoting advertising, stop advertising around football matches amongst other sporting events because of the pressure they're receiving from government, which is very interesting and one to note. And finally, in the US, what we're seeing is a liberalization of the sports betting market. So in other parts of the world, in Australia, Spain, the United Kingdom, we're seeing a contraction of sports betting. In the United States, it's opening up, and there's going to be really interesting to see how that plays out. And then we've got the issue of his close brother or sister, fantasy sport, arguably a really good tool for fan engagement. But in certain jurisdictions, such as in New York and in India, we saw cases being brought that basically equated fantasy sport to gambling, and therefore it was deemed to be illegal. And then finally, around the world, there's various countries, including the UK, who are going for the Gambling Act review at the moment, looking at gambling legislation, particularly due to the concern over public health, and that is the targeting and focusing of people who are addicted. And I think there's a really interesting question around how much money sports gets from the gambling industry and how much it contributes and what those mechanisms are. So that's one to watch going forward. Next up, we have, and by the way, I should no doubt you'll feel quite tired after this. There's a lot to get through, and I'm going to try to get through it as quickly as I can. And as I said, hopefully you'll find the reference materials later. If you do want to go into any of this in further detail, there is a lot of reference materials that you can delve into. So forgive me for scooting over a lot of areas, but I hope by the end of this, you'll see what the global trends that are taking place. So data protection, we obviously had GDPR in Europe. In America, we've had the Californian laws in place. In Brazil, I know that there's a re-emphasis on data, and I think globally there's an interesting case that's taking place that's due to be heard, I think, later this month or next month, Lloyd against Google. In that case, Timothy Pitt Payne QC gave a great overview of that on our panel discussion we had at our annual conference. But to sum up what the outcome of this case could mean, there could be a situation, this is about invisible processing of data. There could be a situation where players and fans are entitled to commercial remuneration due to the third parties who they have not agreed to have their data processed by, who are processing and commercializing their data, whether it be a club, a federation, or another party. And it's going to be really interesting to see. This is a class action that's being brought, and the outcome of that could have some wide-reaching ramifications. We've also got, as many of you will see, and be aware of the use of artificial intelligence, and undoubtedly it can be extremely powerful and useful, although there are some issues of bias within that. And so one application we saw in 2020 was stadiums in the United States, for example, using facial recognition software to detect that the people who bought the tickets were in fact those people entering the stadium. However, during the Black Lives Matter movement, we saw that some of this facial recognition technology was incredibly inaccurate when it came in particular to Black women, but also to Black men. And therefore, the likes of IBM and Google removed their technology from a commercial and public offering because they deemed it to be unethical, given some of the excellent work from, I think it's the Algorithmic Justice Alliance at Harvard. So I'll check that out if you're interested in that. Next up, which I think is more of a future trend, is the Raptors. When they won the championship, the NBA championship 2 seasons ago, they had used artificial intelligence to predict all of their trades over the course of the year and what that would mean in terms of winning the competition. One could see, if we're looking at having competitive balance in sport, or if that is one of the objectives, that the application of artificial intelligence and the access to that may be something in the future that needs to be looked at in more detail, particularly as it could be those who have got access to artificial intelligence may be more successful, and that's really future gazing. But with the reliance on all of this data, of course, increases the risk of cybersecurity and threats. So we saw, obviously, the Man United hacking case earlier in the year, and I'm sure there's been many others around the world, and various attempts we saw with WADA. I think that was 2 years ago now. And also, though, we have seen this type of issue with it being used for cheating. So we saw the Houston Astros case where they were recording basically in stadia using various technology to record the signals being made by coaches to players on the team to sign, what they call sign stealing. And I'll just leave it there, but we've got a great article on that that's worth checking out. Of course, when you've got more money and more responsibility to run a sport or organization, your governance structures matter. Having the, during the Black Lives Matter movement, we saw a focus on the lack of diversity and the significant lack of diversity in leadership and management positions in the world of sport. In the United States, they have the Rooney Rule in the NFL, which basically is meant to ensure that Black applicants for coaching positions are meant to be assured interviews. However, when it was first introduced, it was deemed to be effective, but over the course of the last year in particular, it's highlighted how ineffective it's been. And they've now introduced more positive action measures. We'll wait to see how effective that has been. But also it brought up a question in the United Kingdom around why are there not quotas for diversity in the Code for Sport Governance, which oversees how governing bodies domestically have their governance structures and funding from government for Olympic and grassroots sport. There's been a great initiative, and again, I'm breaking the rules slightly because it's in football, but I just think it's worth highlighting on this point. The FA's Football Leadership Diversity Code is a fantastic initiative. It's an opt-in initiative. Lots of clubs and federations have basically brought in to agree to report and to try to hit certain targets that they're setting for themselves. That's one to watch. And I'm only going to talk about it a fraction, but really it's a whole talk in itself. The influence of human rights on governance. Of course, FIFA have made strong commitments towards governance. We've got the Centre for Sport and Human Rights, which is doing fantastic work. That is going to have a huge influence, as it has done in many other sectors. That over the course of last year, and I'll come on to specific cases later, is going to have a huge influence on the sports market. And of course, we heard about this earlier, but issues around conflicts of interest, and there was cases in the BCCI around the relationship between some of the officials and sponsors. And there's some discussion around the use and application of non-executive directors in sport. But on a related point, we've also now started to see a greater push, as we heard earlier, when you have these independent ethics bodies, and particular focus on ethics and vetting bodies, that officials are now starting to be in the likes of World Athletics and with the International Tennis Integrity Agency, and the likes of the International Ice Hockey Federation have introduced some significant government reforms to recognize that they shouldn't have, not one person in executive positions should have too much power. They should be separated out, and you should have people vetting candidates and vetting executives who are going into positions. So that's really good to see. With that, and we've talked about this already, I'm just going to grab a quick drink. I'm sure the interpreters are very happy for that. The pressures of financial management of governance has also increased. In the United Kingdom, a notable case was the Saracens salary cap case, so which I'll come on to later. But basically, there's a link to the report, which is the Lord Myers report. Lord Myers did following a dispute between a rugby club, Saracens, and Premiership Rugby around the application of its rules around regulating how much salary you pay to players. There was an independent report that was commissioned, and in that report, he made a number of recommendations. Some of them were, which I think are many of them are very good ones, was around transparency and ensuring that not only did you have rules in place, but everyone should be able to understand the decisions that are being made based on those rules and how to access them, and to make sure it was clearly understood what was expected of the participants. It's well worth having a read of that. And we've talked about this earlier, and funny enough, Carlos was touching on this, with sport, particularly football, but many others, becoming much more attractive for private investment with the immense amount of wealth that's been stored up around the world, and people and funds, private equity funds, looking to invest. Who is investing? How much control is giving up? Who are you accountable to? Stakeholders such as your participants and your coaches and other members, or are you accountable, as Jonathan Taylor QC said in an interview that I did with him last week for his book launch with Adam Lewis and Jonathan Taylor? I think sports organizations with private investment can be very attractive and very beneficial, but fully understanding what you're giving away when you take that investment is something that was debated a lot over last year, and it'll be a debate going forward. And really, it's a question of, what do you want? Do you want sustainability, growth, and profit, or profit? Well, what's really the objective? And again, I think this is going to become a very topical area. And I think some of the stuff we heard about in the last presentation highlighted why that's such an important area. Next up, we have integrity. I'm going to scoot over these ones relatively quickly. You'll all, I'm sure, be familiar that we've got the new Wilder Code that's introduced new provisions on substance abuse, particularly relevant for this presentation. So slightly more relaxed approach towards that, and as well to minors and recreational athletes, as a lot of time was being spent, and sometimes there could be perceived as disproportionate sanctions were being, because of the structure of the code, were being given out to these athletes. But again, I think there's still a hotly contested area. Next up, we've had, it's continuing with the rise of sports betting around the world, and with COVID happening and the financial pressures that are taking place, we've seen increased risk, which I thought was very interesting to know over the course of last year, an increased threat due to match fixing. And as well in issues, and I'm sure many of you have seen in esports with competitions, particularly actually related to football, and that were being played in certain parts of the world where essentially there were rigged competitions. And finally, on a related point, we've got the Rodchenkov Act. I probably haven't said that correctly, but in the United States, where you now have a conspiracy essentially to commit an anti-doping offence, and for not targeted the athletes, but targeted the coaches and the officials involved who are planning that. Criminal action can now be brought against those parties, wherever they are in the world, if it impacts American athletes. And again, we've got some detailed viewpoints on that, on the pros and cons. And on a related point, issues on this integrity side, and we heard earlier about the agents and the relationship and the changes to intermediary regulations within football. This intersect between players, agents, and sports teams around the world is something that's been looked into more closely by the revenue and tax authorities. And again, it's likely, as we did see a number of investigations, particularly in football, but also outside of football last year, that's going to continue to grow. Then we've heard already about the horrific cases of abuse And there's more, sadly, and I'm sure there's been many more as these brave individuals, the victims and survivors, are coming out and talking. And we've seen, obviously, in gymnastics around the world, been an explosion of complaints being brought and investigations in place. It's a way to have seen what other ones come up, but I'm glad to hear about the initiative earlier that's taking place, and that's a welcomed initiative. But really what we're talking about here is, does the environment of high performance sport or sport in general create an environment where it's at the sacrifice of the welfare of the individual? And this point of duty of care is going to be one that's going to continue to be hotly contested and debated, and rightly so, over the course of the next year. And it also ties on to the hot topic at the moment, which is head injuries. There's been some class action that's going to be brought in rugby. It's in the process of, I believe, of being brought together in rugby. There's been cases in the AFL in Australia, and of course in heading in football. And it's really about, are there appropriate measures and is the science being applied in these sports to protect the welfare of the individuals, and are there any rules and regulations being followed? Then a notable trend from last year has been the rise of and conversation around both the athlete movement, whereas for player associations, player unions, but also individual athletes becoming much more coordinated. In the US, we've seen various fair pay to play acts being introduced, I think by 20, it might be maybe more now, states in America, where in the NCAA, this concept of amateurism has meant that the athletes have not been able to receive any financial remuneration for playing. There's a case that I'll talk about later that's on that. And of course, prior to the pandemic, there was a lot of discussion around the IOC's Rule 40, which is around protecting the athletes, protecting the IOC and the organizing committee's right to commercialize, and the national associations, Olympic associations, but also with this tension that this is the one opportunity for athletes to actually receive commercial revenue. And where is the appropriate balance? Whilst you want to protect the revenues being generated and in theory distributed down through the Olympic movement and Paralympic movement, but where's the right balance to make sure that athletes themselves can commercialize? On a closely related point was with the Black Lives Matter movement was IOC's Rule 50 and freedom of expression, and when is the appropriate time, and should athletes allowed to be activists or not? We saw the horrific case and execution of Naveed Akafari, who Iranian champion wrestler who was executed and targeted because he was an athlete. And we saw the Belarusian protests around some of the manipulation, they say, of the appointment of officials and concerns around that and corruption within their Olympic association. And of course, there's been huge amounts of focus on equality and representation, whether that's on, and I'm glad to say that it looks like we're starting to see some really positive trends over the course of last year with the gender pay gap in sport, where now, particularly at international level, many countries are now starting to recognize that yes, they should pay their female athletes the same as their male athletes when they're competing, and bridging that gap. But also we're now seeing that there's an identification, there does need to be more diversity and athlete representation in leadership roles and management. And then there's this issue around eligibility, which we'll touch on a bit later, but around gender, particularly around the issue of transgender, around nationality with FIFA and rugby and other sports, looking at athletes moving around the world and certain countries as maybe shopping for athletes, and how that is really being addressed. And then there's some cases with on other physical differences, such as the Blake Leaper case. Now, coming on to dispute resolution, and I'm just about to run over, so apologies. I'll wrap up this. So we've had the Special Federal Tribunal decision in the Casa Semenya case. That's now, she's now filed with the European Court of Human Rights. That's going to be one to watch going forward. We had the Blake Leaper case. Again, both of these are around eligibility. In Blake Leaper, it was around his prosthetic limbs, and did that create any unfair advantage? And we had obviously the Sun Yang case, and in particular, this duty, many of you have read the Swiss Federal Tribunal case around comments made by an arbitrator on Twitter. I think this indicates a greater focus and scope that will be given to arbitrators, their position, their opinions, which previously maybe hasn't necessarily existed in sports law, that I think will continue to be as people become more au fait with legal issues in sport and the Court of Arbitration for Sport and the likes of Sports Resolution and other organisations. I think the arbitrators will start to see a lot more focus and scrutiny than maybe they've seen in the past. And then we've got Sean Alston and his series of cases that are taking place around name, image and likeness in the US. There's a big Supreme Court hearing that's about to potentially change the whole economic and potentially governance structure of the NCAA. We'll wait and see. And that is basically allowing, really what this case is about, is allowing athletes to, in the NCAA, in college sports that generates billions of dollars a year, to be able to commercialize the use of their image, essentially in their likeness, whether it's in video games, on sponsorship deals, etc. Then we've had the Ali Riza and others and Turkey case, which again is a football case, so I'm not meant to talk about it. Sorry, Emilio, get in trouble. But that was around the independence of an arbitral body. And again, you're starting to see the human rights start to become more pervasive. And these bodies, which we heard earlier, whether it's a sports organization or a dispute resolution body, start to have to become much more accountable and to ensure that people have access to justice, have access to a fair hearing. That some of these rights that we've maybe to say implied have been in sport are now actually being enforced in sport. And of course, we've had the WADA against Rosada case. Russia will not be competing under the Russian flag, but there's whole issues around that. But there's also, it's worth checking out the AIU's decision around a number of Russian officials and athletes that came out. I've talked about the Premiership Rugby case against Saracens, and also we've recently, in December, we had the International Skating Union Commission case at the European General Court. And I think what we're starting to see, and these are some of the trends and around this, is around the competition law seems to be one of the areas where we're going to see a lot more focus. And for those of you that would like a much more informed view of this, I'd recommend the interview I did with Jonathan Taylor and Adam Lewis QC, who talks about this in a very articulate and informative way, and he's much better to listen to than me. And because I'm conscious of time, I would come on to my closing slides. So really what we're going to see is some increase in antitrust competition law cases, it seems, particularly with private investment coming in and this autonomy of sport starting to come more and more into question. We're also going to see, as the business of sport has evolved, the issues of human rights and the application of human rights becoming more prevalent, and athletes and others being more willing to take cases, and advocates for that matter, being willing to take human rights cases where maybe previously they haven't. And also we will see people challenging the independence, as we've seen already in Mutu and Pechstein cases, the challenge of structures and the selection and conduct of arbitrators, which maybe hasn't come under as much scrutiny in the past. So that was a whistle-stop tour of an analysis of the sort of key issues that have taken place outside of football. And I apologize, I did cheekily putting some football law references there. I hope that's very interesting and very relevant for you, and hopefully it will give you some indication of what we're going to see moving forward. So really, to surmise, we are going to see greater emphasis on compliance and risk management, whether it relates to data, whether it relates to processes around protection and welfare of athletes and safeguarding, as we heard earlier. We are starting to see more legal expertise. And as Adam Lewis said, the sports governing bodies should embrace these challenges. They should be ready and have their house in order and accept the fact that as they get more international profile, as they get more profile, as they get more exposure, as their stakeholders become more informed and more equipped to take legal challenges, they should embrace that, because it will help them become more robust going forward. And I would argue that's certainly been the case that FIFA have taken with explaining some of their regulations and processes of today and in previous years, but also tomorrow. Then referencing Professor Simon Roth and Dikea, and I'm going to say her name wrong, Christosafaldu, who are experts in sports diplomacy, I do think the role of lawyers in being more diplomatic, let's say, through sports executives, using the tools of communication, representation and negotiation is going to become much more important, as rather than being reactive to legislation and policy, being involved in it and the developing of it. And then really understanding the role of sport in society, what it really means, and who are these bodies accountable to, whether it is the private equity that's coming in or whether it's the stakeholders, how that's going to pan out, I think is going to be one to be really interesting. And thank you all for sticking with me for this. I apologize. It was a lot to get through and I'm 6 minutes over. So I think that's all for me. If you do want to get in contact, you can. And again, here is the reference materials. There's a lot of it. But if you are interested in looking things in more granular detail, please do check that out. And of course, you can message me if you would like to discuss any of these points or go through them in a bit more detail. I hope you've found that useful and hopefully provides a real whistle-stop tour of the key developments from last year and what may be issues going forward. And thank you.
Thank you very much, Sean, for this very detailed presentation. We have actually no questions, so there are maybe two reasons for this, either because your presentation has been very detailed, or maybe because we have been live now for more than 4.5 hours, and I think that somehow all our plus minus 400 viewers that have been following us today throughout the day also slowly need a break. So I think we have come to an end. It has been a very interesting day one on the review of 2020. Tomorrow, we will have another very exciting day. Tomorrow is dedicated on the future. So we'll get some very interesting presentations about the latest reforms on the various rules, being it the FIFA eligibility rules, female football, the amateur players, the coaches, and of course, the challenges ahead. And all this, we will end up with an excellent roundtable that will be discussed with 4 external experts on what FIFA can do better. So don't forget to be back here tomorrow, same time, same place. I hope that tomorrow everything will work from the very beginning. Always remember, you can follow us on English, French, and Spanish. Muchas gracias. Have a nice evening. See you tomorrow. Bye-bye.